Let's be wrong. Item 33 to 38. These are matters where for construction of model degree college, some government has started construction. Now the landowners are saying that we have never consented, we have never donated the land. And as a result, the construction is stopped. And within March, we are unable to complete the construction. We will not be able to use the fund. And for the next year also, fund will not be allocated by the central government. So there is some urgency in the matter. Today, in the first episode, I wanted to pray for upgrading the matter. My land is preparing for the private party and the requisition to.
I'm the requisition. I'm sorry. I'm the requisition.
Yeah.
Private party is
The second half, I've got some difficulty. First half, your lordship.
No, there are so many motions.
Well, first half, I have some difficulty. Let it be some other day. Can be on 18th if my management is no.
18th of January.
Yes, ma'am.
18th it can be taken, but I have got 2-3 matters on that.
18th or 24th? As your
24th.
As it's convenient.
24th.
Oh,
There is some urgency because this way or that way some decision has to be taken.
okay.
33 to 38.
Expressing urgency. Mr. D. Mojumdar, Learned Additional Advocate General, Assam. Preparing for the respondent, state respondents from a has expressed urgency in the matters and has sought for listing of the case on a fixed date. Post of Mr. M. Dottal and a counsel for the petitioner is present for the petition. Is present as agreed to by the for the parties, release the cases on 24th. 24th?
All right, 24th.
Diploma.
Can it be slightly higher on the list so that it can be? Issue is otherwise very simple, man. The lordship passes.
Or let it be 23?
23.
23 million some difficulties. Or 25th method if it's miscellaneous.
Or let it be 30th when it's a Tuesday, so that it can be
30. Okay, 30.
Let it be
Lordship, we kindly observe that it will be
30, then it is Tuesday, it will be taken up.
Diploma.
Make please, your lordship.
Ah.
My lord, I beg to mention item number 8, lordship. I may be allowed to withdraw the petition with liberty to file a fresh because I have gone through the records that 227.
I think it is,
Lordship,
Okay.
because it may be converted, but difficulty is there, so because of which
Mr. K. Mojumdar and counsel for the petitioners.
I'll file separate fresh petition.
Because section 28 says it is TRBC.
Lordship,
TRBC.
very contrary, lordship. And 482 will not lie because of last judgment of the Kamaksi. Kamaksi judgment 482 will not come. So for which 227 lordship is there, lordship. I pray lordship would do the liberty to
Okay.
file a fresh.
And counsel for the petitioners have submitted that the petitioners want to withdraw the petition with the liberty to file a press. Mr. PP is available. Okay, then we have the above submission by Mr. Mojumdar. The petition is withdrawn, is dismissed and withdrawn with the liberty as paid for.
March of
My please, Your Lordship. I paid for listing 3 motion matters, eviction matters tomorrow, Your Lordship.
Wednesday.
No, Your Lordship.
Wednesday.
The already making is there, Your Lordship.
Wednesday, tomorrow we have some difficulty.
7 days time is granted, Your Lordship, on receipt on, petition received the notice on 2nd, and 7 days time has granted to vacate the land, Your Lordship. Tomorrow, Your Lordship, urgency, Your Lordship.
May I please, Your Lordship? My lord, I beg to mention for listing of an admission item, my lord. We have challenged the, my lord, an order passed by the registered cooperative societies, my lord. Wherein, my lord, a person has already been sacked from the, as a shareholder, as a member. but he has been, my lord, allowed to continue as a chairman of the, my lord, society, and that is under challenge. If it is possible, my lord, on coming Friday, my lord,
Friday.
oblige.
May I please, your lordship? My lord, in this case, my lord, without informing me, my lord, my electricity is disconnected, my lord. My meter is removed. So my-
Wednesday,
tomorrow, my lord, kindly.
Wednesday.
I beg to trouble your lordship of item number 59. There is a matter that I mentioned last week, your lordship, citing some urgency. Item number 59, your lordship. It's an IA.
Hmm.
But the matter is slightly urgent. If your lordship can kindly.
Why? Why
Yes.
urgent?
Yeah, urgent, your lordship, because we have challenged disciplinary proceeding initiated on the basis of the anonymous complaint. There's an interim order which is continuing. In fact, tomorrow is the date when the petitioner has been asked to adduce evidence, your lordship. Now he is contesting the matter on two forums. The maintainability of the issue is before your lordship. Whether the
It is not possible, Mr. Sharma.
I understand, your lordship, I understand, but if your lordship can,
Difficult. Let it be there
yes,
if
yes,
time permits.
yes, I'm grateful, your lordship.
Mr. Das and Mr. Chaudhary, there are so many matters. Can it be your cases tomorrow? We have lesser number of cases tomorrow. Other little consume some time. Tomorrow?
Yes, sir.
Take up. Possible as a first item, if possible. Thursday.
Okay.
Thursday, this code will not be available.
Wednesday, my-
The Wednesday, from Wednesday onwards, this code will not be available. This code will be sitting in Tripura. We'll see tomorrow. Okay. Okay. Kali did you? Kali Garden? Huh? No. 3 and 4. 3. No. 4 and 5. What are you order to go? Navigate লিখি Navigate লিখি দিব as agreed to লিখি পেলাই list the cases tomorrow.
Yes.
Huh?
Interim order.
Interim order.
May I please, your lordship? I beg to mention for listing repetition, lordship, 5368 for Wednesday,
For what?
land acquisition matter.
Land acquisition. Admission.
Yes, lordship.
Admission. Affidavits are filed.
Yes, lord.
Huh?
Yes.
File.
Maju.
May I please, Lordship, I beg to mention number 54, Lordship. Lordship, the youngest counsel of this case is not present, Lordship, and Lordship consent with the opposite.
54.
54.
You want adjournment?
Yes, and Lordship consent with the opposite party, Lordship, kindly adjourn the matter after Bihu.
MS.
MS M. Deka, behalf of.
M.
the
Deka
product.
Learned Counsel appearing for MSG Bora Learned Counsel for the petition has sought listing of the case after 2 weeks. So it is submitted that consent has been taken from the Learned Counsel for the other sides to make the prayer is allowed. List the case after 2 weeks. On a date to be.
Obliged, Lordship.
Meet these are Lordship, I beg to mention a matter for listing. The matter pertains to non-implementation of the order passed by Learned Rera upon the respondents.
RERA does not have any executing authority.
No, Lordship. Lordship, on Wednesday.
Next week, not for next week.
Much order.
May I please, your lordship? My lord, I beg to mention item number 3, my lord. Can it be on Friday, my lord? Today is some difficulty, my lord.
Item number 3.
3, my lord.
No, Friday, then on 18 or 19?
18, my lord.
18.
Obliged.
On the prayer of Mr. Ziuddin,
Yes, my lord.
Learned Counsel for the petitioner, list the case on 18. 18 কিমান আছে?
Obliged.
May I please, Lordship? Lordship, I beg to mention item number 28, Lordship. I am for the petitioner. Lordship, may kindly adjourn the matter for today.
Order
Adjourn the matter for 1
Today.
week, Lordship.
for
I am
one
for the
week.
petitioner.
On the prayer of Mr.
D. Sutia.
D. Sutia, Land Council for the petitioner. The case is adjourned for a week. Release the case after a week.
Obliged.
For motion item number 1,
Maybe the Lordship.
Hmm.
Lordship. Page 9 is order, Lordship. And relevant portions, Lordship, page 11.
Mr. Counsel, it appears that the name, he is no longer in the office perhaps. Mr.
Yes,
Sharma?
Lordship, yes. After filing of this, Lordship, today, Lordship, I bring this amended cost title, Lordship.
File it then. Otherwise, no,
Yes, Lordship, yes.
no purpose will be served.
Yes, Lordship.
Or you can file it afresh.
Lordship,
I think it is better. Mr.
I hope, Lordship.
You were absent on 2 occasions or what?
Lordship, last occasions, Lordship.
Mr. Ihawk, Learned Counsel for the petitioner has submitted that since the incumbent in the office of the Deputy Commissioner has since been changed, the petitioner wants to withdraw this contempt petition with the liberty to file a press impleading the present incumbent in the office of the Deputy Commissioner. Deputy Commissioner, Kamrup.
Come to Metro,
Metro. In view of the above submission made by Mr. Hawk, Learned Counsel for the petitioner, the contempt petition is allowed to be withdrawn with the liberty to file a press.
highly obliged, Lordship.
item number 2,
May it please your lordship.
Hmm.
My lord, under the Biswanath Municipal Board, the petitioner before your lordship purchased a plot of land, my lord. And thereafter for construction of his house, he applied for permission. And the plans and drawings were also approved. And now, my lord, when he initiated the construction permission was also issued by the Biswanath Municipal Board. Now, when we commenced with the construction, some persons, they raised a frivolous complaint, my lord, that his land abutted, the particular byline abutting his land is a private patta land, so he cannot be granted this permission. Immediately he applied for the copies of the complaints, my lord.
Hmm.
And when he received the copies of the complaints, he could not find any particular title deed of any individual who were the complainants. So who are the even private respondents before your lordships today that
I think you approached earlier.
lordship,
You approached earlier.
we approached earlier, my lord.
Ah.
What happened, my lord, in the previous proceedings, records were also called for. We examined the records, we allowed to examine the records, and we found that there is no title deed deposited by any of the party to show that the particular land belongs to any individual. Now, that was actually for all practical purposes.
The proceeding was not brought to a, has not been brought to
To the logical
There is
conclusion.
there is your
At
case.
this stage, I pray for notice, my lord.
Heard Mr. G. Rahul, Learned Counsel for the petitioner. Urban development.
Respond number 1, Lord.
You can accept.
Lordship.
Mr. H. Sharma, Learned Traditional Senior Government Advocate, Assam for the response number 1. Full stop. The petitioner is aggrieved by the inaction, alleged inaction on the part of the respondent. Vishwanath Sariali, Municipal Board
Municipal Board.
authorities in not bringing the proceedings initiated by a stop construction notice dated 30/01/2021 in compliance of the direction made in an order dated 2/11/2022 passed in a writ petition, WPC number 2354 2021, preferred by the writ petitioner earlier within the stipulated 45 days. Within the period mentioned therein in paragraph 11 of the said order. Full stop. Issue notice returnable on 9/2 as Mr. Sharma appears and accepted. For one, no formal notice, the petitioner shall take steps for service of notice upon the respondent number 226 by registered post BTD within 3 working days.
Your lordship has fixed it on 9th of February.
Obliged, my lord.
Item number 6.
May it please your lordship. Lordship, I'm praying on behalf of my senior lordship. She has undergone some surgery, so I'm praying for an adjournment today. Let the matter come up after due vacation, lordship.
Lordship, in fact, we have filed our affidavit in the matter. It may be tagged with the record, Lordship,
Not tagged.
not tagged.
Okay. MS Hart,
Yes.
MS
A das, lordship.
ADAS, Learned Counsel for the petitioner, appearing for the petitioner. Mr. Z Das, Learned Counsel for the respondent number 1, 2, and Mr. H. Sharma, Learned Additional Senior Government Advocate for the respondent number 3. Post of MS Das, Learned Counsel appearing for the petitioner has submitted that she's in the case she is being led by MS P. Chakraborty, Learned Counsel, who has undergone a surgery recently and is not in a, and has thus submitted that MS Chakraborty is not in a position to argue the case today. She has therefore prayed that the case be listed after after 2 weeks. So, as agreed to by the council for the parties, release the case on 24.
Lordship, can it be on 22nd, Lordship?
29.
Lordship, our affidavit may be called for, Lordship.
Mr. Das has submitted that, Mr. Das, Learned Counsel for respondent number 1, has submitted that the an affidavit in opposition has already been filed on behalf of the respondent number 1, but the same is not tagged with the case record. To stop the registry to verify the same and tag the affidavit in opposition, stated to have been filed on behalf of the respondent number 1, with the case records.
Deeply obliged, Lordship.
Item number 7.
Please, your lordship. On the last occasion, your lordship asked me to give the date when my father expired. He expired on 10/3/1995.
Hmm?
Yeah, 10/3/1995.
What is your father's name?
Father's name is Asadur Jaman.
10?
10/3/1995. And my uncle Rashid Ali died on 7/5/2003.
7/5.
2003.
Why you are aggrieved here?
Yes, I am aggrieved by the eviction order, your lordship. What happened? I am giving the brief fact of the case again, your lordship. 31 bighas of forest village land was allotted in the name of our grandfather, your lordship. Thereafter, he had two sons, my father, Ashidur Jaman, and my uncle, Rashid Ali, your lordship. Our grandmother.
Come to page 32.
Yes, your lordship. 32, your lordship. Yes, your lordship.
This Imran Hussain and others, that is petitioner.
Yes, Imran Hussain is.
Huh?
Yes, your lordship.
Petitioner.
Okay, your lordship.
Has
Only
been
regarding-
enjoying land measuring 8 bigha, 12 katha, 0 chotok under dark number, so and so, and 5 bigha, so and so,
These are
under dark
undisputed
number,
land.
so and so. 8 plus 5, 13.
Yes.
It was originally allotted in the name of their father, late Azadru. On the other hand, Kamaluddin. Kamaluddin means
Kamaluddin is my cousin brother. He also expired on 18 to 20.
Kamaluddin, son of so-and-so, has been enjoying the land 17 bigha,
Yes.
which was originally allotted.
Now, your lordship, kindly turn to page 33, your lordship. Page 33, last paragraph. Land under other dug is undisputed. Now, you are here.
4 bigha of Dag number
Yes.
30. Now,
Yes. 3
where is
bigha.
the allotment? Where is the allotment?
3
By the
bigha.
forest authorities.
Your lordship.
Where is the allotment in your name by the forest authorities?
No, that's why we have filed a representation. Actually, the land was allotted in the name of our grandfather. Now, your lordship, after he expired, our grandmother distributed equally to both the son, your
So
lordship.
how the grandmother can distribute all this? These are forest land.
Forest land.
You cannot, on your own, within the family, you can distribute and this take, give and take.
By inheritance. I accept your lordship. Now, I am agree with your lordship. Our uncle,
Where is
He-
forest? Forest council.
notice may go, your lordship, and let them file affidavit. I am agreed by the annex of 1, your lordship. Land transfer order initially, my uncle secretly transferred the land in his name. Then I filed application for correction of the land records. Initially on 13/12/13, then 17/9/16, and lastly annex of 3, 17/9/19.
Eviction process was carried out or not?
Yes, after that, the DFO asked the range officer, concerned range officer, to conduct an inquiry and submit a report. I am the applicant. Now, without hearing me, my brothers, he passed the impugn eviction order. That also expired on 2019, your lordship.
Then what happened due to this
Yes,
eviction notice?
we came to learn when in 2021 that eviction order was being carried out. Was intended to be carried out. We then requested, then they went away. Then we filed a representation before the DFO. Their representation is pending. Representation annex 7, 17/11/2023. On our request, the forest official has not carried out any eviction process, but they want that we'll again come for eviction, your lordship. And we file a representation. That representation is pending, your lordship. Annex 7.
Forest.
Lee Gogoi was there earlier. Lee Gogoi was there.
Let forest come. We can dispose of the representation.
That can also be done, your
Consider a
lordship.
representation. If the forest people agree.
Item
number 9.
My lordship, my senior is in court number 15. The matter may be taken.
Why it was amended Constitutional I asked for?
The sense of the response number 2, state of Assam.
No department was
No
mentioned
department was mentioned.
in response number.
Now you have been given time. It was last listed 22/12. 15 days. You did not have time to file the amended cost title.
Oh, it was not filed.
Huh?
It is not filed.
Not filed.
Oh.
My lordship,
Not filed.
the petitioner could
Even
not
after
able to.
granting opportunity.
My lordship, the petitioner could not able to come to Guwahati, and on Saturday he has come and.
I don't think amended cost title is required to be submitted by the petitioner with the signature.
Yes, my lord. Absolutely no prima
I don't
facie
know.
case, my lord.
I don't know. That all privacy case is not there, but at least we have to issue notice. Issue notice.
Lordship.
No point waiting for this. Nobody will accept notice for response number 2.
Fine.
Hard.
Department denied.
Mr.
M.K. Das.
M.K. Das, learned counsel for the petitioner. And Mr. H.K. Das,
One and three.
standing counsel, this is the Guwahati High Court, for the response number 1 and 3. Full stop. Mr. Sharma, learned H. Sharma, learned additional senior government advocate Assam has submitted that in view of inadequate description in respect of the response number 2 in the cause title of the writ petition, he is not in a position to accept the notice. Full stop. The case projected. Full stop. It is as per office note. As per office note, dated 5/1/2024, the petitioner has not submitted any amended cause title in terms of the notification number 79 dated 19/6/2023 and in deference to the order dated 22/12/2023. An advertisement
Page 20.
was issued on 20/02/2023 by the response number 3, inviting applications from intending candidates for filling up 5 number of post of peon within bracket grade 4 in the establishment of the district and sessions judge, Kokrajak. As per the advertisement, the candidates applying for the post of peon must have to pass class Roman 8, but candidates who have passed class Roman 12 and above, it has been specifically prescribed in the said advertisement that the candidates who have passed class 12 and above shall not be eligible for the state post of peon. It was further prescribed that any such application not conforming to the prescribed educational criteria is 20 Thursday shall automatically stand cancelled. For that purpose, the applicants have to produce a self-declaration certificate along with the application form mentioning that, quote, he/she has not passed HSSLC or equivalent examination or above, unquote. The petitioner responded to the said advertisement dated 20/02/2023. After appearing in the written examination on 2/4/2023 and in the interview on 24/6/2023, the response number, a selection list was published by the response number 3 by notice dated 7/1/2023. The petition was one of the selected candidates, one of the 5 selected candidates. An appointment order dated 12/7/2023 came to be issued, whereby the petitioner was appointed as peon in the establishment of the response number 3. Subsequent to the appointment, the petitioner was served with a notice dated 11/10/2023, informing the petitioner that complaint had been received that the petitioner is a holder of a Bachelor of Arts degree. And petitioner was asked to so cause as to why necessary action should not be initiated against him. A reply to the said so cause notice was submitted by the petitioner on 12/10/2023. By impugn order dated 13/10/2023, the petitioner was terminated from service with immediate effect by the respondent number 3. Full stop. Did he explain anywhere?
He has
Graduate
admitted,
or not graduate?
he has admitted in his reply BA pass,
Which one?
page 30, para 3, down below, my lord.
Even now reading
In BA pass.
BA pass, I don't know what is the meaning of it. Mr. Das.
Yes.
Sorry,
HS, because
Ah.
class 8. 12 and above.
notice returnable. Mr. Das, standing counsel GAC has submitted that, and it is a petitioner in his reply has clearly admitted that he is a graduate on the date of submission of the application in response to the advertisement dated 20/2/2023, and as such, no interference is called for in respect of the impugn order dated 13/10/2020. Issue notice returnable on as Mr. Das has appeared, accepted for 1 and 3, no formal notice. Extra copies within 2 working days.
Item number 10, deeply open.
My lord, here is a case, a part of the land already has been acquired, my lord, for construction of the road.
Yes, on the previous dates,
Yes,
that notice served upon you.
yes. Now, there was an inspection, my lord,
1 minute.
and the outcome of the inspection has not been communicated to
No,
us.
that 39. 39.
Yes,
Then I try to see this second proviso to section 3(1).
yes, my lord,
Page 39, this notice form A.
yes,
This is meant for something else. This is not in the book.
okay.
This is not in the book.
Okay.
Whether that is in the book.
Form A, yes, it is there, my lord.
No, form A is there,
Uh-huh.
but second proviso,
Second proviso is not there.
not there.
So government press must have acted miserly, my lord. My lord, basically the case is, in this case, my lord, what we're trying to say is,
So this is second proviso is
Uh.
where it is necessary to provide the land to less or displaced person.
yes,
Such land shall not be requisitioned unless the person interested in the land has been given an opportunity. This is meant for different thing. This form A is completely different.
yes.
It should have been form B.
My lord, whether it is A or B, nothing has been done, my lord.
No, that
There
is
is
why.
no notification under
No.
3(2) which has prevented me from filing an appeal before the state
No,
government.
no, that is why
Yes.
I'm asking for your assistance. This should be form B.
B.
And it should be followed by form C.
Yes,
Then only you can take position.
yes, but they have already taken possession. They've started
Then-
work.
Then explain the situation.
I have,
If a statute prescribes
my lord,
that a thing is to be done in a particular manner,
Then it has to
then
be.
it must be done in a particular
Lord,
manner. That is what. Simple.
As has been apprised by my learned friend, my lord, matter has been discussed as per the discussion, my lord. The decision of the committee, my lord, decision of the person present official, including the petitioner, my lord, they agreed to, my lord. Lordship, my lord.
কি agree করবি?
মই প্ৰথমখন লিখিছো, এইখন দি-
There cannot be any waiver of fundamental right, my lord. I do not know on
No.
what basis some documents
Dispute
are
was-
being shown.
dispute was, yes.
There cannot be waiver of
In pre-
fundamental
in-
right.
in
That is a
presence of
simple
all
proposition.
concerned, my lord. The decision was taken, my lord,
And
and the
wait.
petition was.
See whether, because they are relocating the towers.
Okay.
Find out, it may be to your advantage.
But if they are relocating, then
Please find out.
perhaps our
I don't know.
request is
please take-
answered.
Now petitioner themselves are present.
No, Mr. Chaudhary may have to take
No,
instruction.
no, my lord. The
Please
question
read,
is.
read it.
Yes. It is writing as the honor to have the meeting has been given in the chamber.
Reason petitioner, my lord.
You can come back. Whether it is because something has been relocated now. If your middle portion is saved,
Yes,
and if it is relocated by the side, maybe
little bit.
to your advantage.
Yes, yes.
Find out.
All that will have the instruction, my lord. Yes.
Exactly.
Oh, oh, oh.
You provide a copy of this letter
Yes, yes.
to Mr. Chaudhary so that he can come back with the instruction. If suppose relocation to your satisfaction, I don't think
Then
that.
will not pursue.
I can read, no?
Thank you. They have given, my lord.
Okay, heard Mr. K. Chaudhary, learned senior counsel, assisted by Mr.
Yes, yes, yes.
Mr. F. Reddy, learned counsel for the petition, and Mr. B. Goswami, learned additional advocate general Assam, assisted by Mr. S. Borua for the respondents. So stop. Mr. Goswami, learned additional advocate general, has placed a communication bearing number so and so dated 6/1/2024, wherefrom it transpires that a meeting between the petitioner side and the respondent side was held on 3/1/2023. And some decision as regards to relocation of tower had taken place. First of Mr. Chaudhary, senior counsel appearing for the petitioner, has submitted that he has also been supplied with a copy of the said communication dated 6/1/2023 and has submitted that he would like to take further instruction in the matter. First of as when
18th, my.
18, okay,
18th.
as agreed to by the learned counsel for the parties, this is the case on 18. 19. You are available 19.
Till 19 I am available.
19.
All right.
Deep level.
May it please your lord.
Yes.
In quite difficult circumstances, the petition is before your lordship, my lord. My lord, in a nutshell, it arose in a controversy.
Case 59.
59, prior to that, my lord, 59 is the conclusion. How they played fraud with the court. That is, and we were hoodwinked. My lord, it started off with a controversy as to the illegal construction on my neighbor's side. We find the municipality was not taking any action. We filed the writ petition.
We can issue notice at this stage.
But also, I'm praying for a notice on suo motu contempt, my lord. That's why I'm on. That's what I'm on. Kindly see the action.
I've seen because they have at least initiated some disciplinary action against the chief executive officer.
What I am on, my lord. My writ petition, my contempt petition, all got.
I have seen.
Now I'm remediless.
I have seen.
I'm
You
remediless.
have the remedy here in this petition.
That's why I'm playing.
So motu complaint is a drastic measure. Let us
Because
have
they,
their,
because they
let us
placed
have
it.
their response.
Then an observation that that prayer, Suomoto content will be considered on their being present method. That would do. It was inter-party order. I want that method. They placed it on the before the court. They knew it. It was a fraud.
Heard Mr. S. Boni. Learned counsel for the petition. Mr. Boni, learned counsel for the petitioner has submitted that petitioner had earlier preferred a petition. How many? One repetition.
Initially two.
Repetition?
First one was 1749 of 2022.
17 repetitions.
Synopsis link.
WBC number 1749 2022. And WBC number
2405.
2405 2023. The petitioner had to prefer the repetition in view of alleged unauthorized construction of a building in the
It was a
plot
boundary
of land adjacent to the petitioner's plot of land. Full stop. This repetition was 2405 was
2405.
final order?
Final order. Watch it.
Is there?
Yes, yes. Final order is at page 54. It was closed as infraction.
As during the pendency of the repetition, WBC number 2405 2023, the respondent
Page 51.
Karimganj Municipal Board authorities had issued a demolition order in respect of this building on 30th 2023. The repetition was disposed of as nothing was found to have survived in the repetition. Full stop. But the respondent authority, respondent Karimganj Municipal Board authorities had in a meeting have in a meeting
19. Towards the bottom, page 59.
having a meeting, held on 1/9/2023, took a resolution to declare the order demolition order dated 30th 2023 as not to declare the took a resolution to declare the demolition order dated 30/8 2023 as null and void on the premise that the said demolition order was issued by the executive officer, Karimganj Municipal Board, exceeding his jurisdiction, and without prior approval from the from the chairman, Karimganj Municipal Board. Full stop. Alleging such action on the part of the respondent, Karimganj Municipal Board authorities as arbitrary, unjust, and illegal. The instant writ petition has been preferred.
Also on the ground of fraud, because the contempt and writ petition were closed because of their stand.
The petitioner has also alleged fraud on the part of the respondent, Karimganj Municipal Board authorities. Full stop. Issue notice returnable on
9/2.
9.
9 February.
No state respondent. Okay. The petitioner shall take state for service of notice upon the respondents by registered post with AD within 3 working days. The the petitioner has also prayed for drawing up suo motu contempt proceeding
Page 23.
against the respondent authorities. Issue notice.
That would be considered on their appearance that that line may be
We'll see
necessary.
that. Otherwise, it is fine.
Right.
Item 12.
May it please your lordship, my lord. The petitioners were, it was listed,
Yes, yes. High-handed action.
yes, high-handed.
High-handed action. Yes. Any instruction?
Lordship, most probably it's for the first time today.
No, it's second time. Instructions, Navasis Goswami appeared last occasion, my lord.
Ah.
My lord, what they have done, my lord, they have closed the ingress and egress to my shops, to our shops.
Is it part of any civil action?
No,
Any civil
no,
decree?
no. No.
No instruction.
One proposition that I have heard that somebody went to go for demarcation. But while demarcating, you cannot stop, close the ingress and egress. But no officials were there for demarcation actually. These were goons escorted by the police and the circle officer.
But I am making a preliminary objection, Lordship, whether this forum is the appropriate forum, as because it's a purely a
That is why I
private
asked.
dispute, but Lordship, they have certain allegations are made against the OC as well as the circle officer. If any affair is lost, then and that affair is not registered, whether this is the forum who directs the OC to register a case,
My lord.
this is not
no-
the forum, Lordship.
No, my lord, my learned friend is raising a very basic question. I know, my lord.
Only question is concerned how this building has been barricaded.
Huh. They removed the
Barricaded
police.
and-
So it's a civil dispute, not with the.
How can it be civil dispute, my lord? There is a limit.
Let him finish. Lord.
Yes, yes.
Do not raise your voice. It will not
But how can it be civil
result
dispute? Tomorrow,
to any positive outcome.
my lord, what my respectful submission is, some goons comes and close the entrance of my house, entrance of my shop, escorted by police. Okay, fine. For a moment,
Okay, that is why if the police presence is there, that is why I have asked
my
the
lord,
state council.
for a moment, remove this my submission that escorted by police. No police was there. Some goon came and did it. I went to police station. We all went to the police stations. They received my affairs. No action. Is it not the forum, my lord?
No, then it is not forum. If it is not action, then it is not the forum.
My lord will
But
appreciate
if the respondent number 3 and respondent number 4 have gone there and to barricade your building,
my right to life has been.
we'll see to that. Why you are not getting the instruction?
Most probably, Lordship, it is the fault on our part, Lordship, as because there is no such knocking on the other head. So, Lordship, I have to.
We served the copies immediately on that day.
Maybe, Lordship, but I have to.
Because without knowing, it is very difficult why there is high-handed action alleged on the part of the respondent number 3 and the respondent number 4.
Lordship.
If they have, the circle officer have gone there.
Yes,
and
the circle officer.
Officer in charge have gone there.
Can it be like
There
this?
might be something.
My lord, can it be like this? If lordship passes an interim order today.
I'm not passing any interim order without knowing the exact facts.
My
If
lord,
you,
they are
you are
not-
tenant, you
my-
are tenant.
Right.
You are tenant.
My lord,
Let me be clear.
my lord.
You are tenant. Suppose if there is, because of the presence of circle officer, I'm saying, if he has gone there with the officer in charge, there might be some civil dispute.
No, dear, my lord, there is none.
That is why I have asked for the instruction specifically. Talk about telephone then, we'll take up at 2.
At 2, Lordship, at 2, Lordship.
Because otherwise, if there is a civil action, then there is remedy lies elsewhere.
My lord, I understand that much, that.
We'll see to that.
My lord
We'll
would
see to that.
appreciate. No, my lord would
If
appreciate.
things
Kindly
are turned up,
Since
Lordship, may I get a copy of this order by making a photograph outside, Lordship, not inside the court, Lordship,
এটা হেৰি দি দিব, print out এটা দি দিব.
so that I can get.
We'll give you a printout, we'll
Lordship.
take up at 2.
Lordship.
my lord, what my respectful submission.
Nothing will fall. Event will not fall till 2 o'clock. It is already barricaded. That premise has already been barricaded since 22nd December. So we'll wait for 2 o'clock. Let him.
Lordship, Lordship, Lordship.
But in the meantime, may I make one fairness?
Who are you?
I am respondent number 6.
Means, okay.
Private response.
Private response. So you have come.
Friend can give a copy to me, Lord, because what I have seen from the synopsis, Lord, is that respondent number 5 is the owner of the plot of land. And your lordship would see the averments made in paragraph 2.
So he has the copy then, my lord.
No, I have seen, that's what I have
The
said.
court has not issued notice.
No, I have seen.
No, I will not provide any copy. Why should I, my lord? Court has not issued.
Don't raise the voice in before this court. That will not serve any purpose. Yes.
Lord, therefore, I am praying that my learned friend can.
Go through the, I am permitting you to go through the.
That may do. Because I have just hardly 2 minutes, Lord, I have seen, Lord.
Item number 13.
Kindly pass over the matter for time being.
Kyle is not available.
My senior is next in court number 2.
Item 14.
May it please your lordship.
Yes.
Lordship, my GST registration has been cancelled, lordship. By
Yes, Mr.
Lordship, notice may go because it was cancelled on 22, September 22, and appeal was disposed of on 18/11/20.
What about page 67 order?
Lordship, I have seen that. Lordship, I have to take instruction, but I'm praying that.
Say paragraph 7. Paragraph
Yes, sir.
7. Paragraph 7. Page 68.
Yes.
What benefit would accrue to the state? Paragraph 7.
Yes, madam. Also short date, Lordship.
Okay then. Hard MS.
B dash.
B. Das.
B dash.
Learned counsel for the petitioner. And Mr. B. Chaudhary, learned standing counsel, finance and taxation department. For the respondent number 2, 3, 4, 5. Also heard. Yes, CGC, any CGC? Mr. P. Medhi, learned central government counsel for the respondent number 1. Agreed by the cancellation of the petitioner's GST registration. Some of the petitioners preferred the present registration. Mr. MS Das, and counsel for the petitioner, has submitted that in a similarly situated. No, sorry, the petitioner is similarly situated like the petitioner in WPC number, in the repetition, WPC number 1198/2023. And as such, the petitioner has paid for a similar order like the order dated 17/3/2023, whereby the said writ petition, WPC number 1198/2023 was disposed of. Mr. Chaudhary, Standing Counsel, Finance and Taxation Department, has paid for time to obtain further instructions in the matter. Post of issue notice returnable on 29/1/2023 as Mr. Methi, Clarence CGC, and Mr. Chaudhary appeared, accepted notice, no formal notice, extra copies within 2 working days. Place the case on 29/1.
Bless Lordship.
Item number 15.
May I please, Your Lordship? The petitioner is the owner of G+1 building, Your Lordship, and adjacent to his land, Your Lordship, a PHE plant has been constructed from which sludge and dirty water enter into the.
What has been constructed?
PHE plant under JJM, Your Lordship. Jal Jeevan Mission, Your Lordship. From
Water supply scheme, PHE plant, okay,
PHE
plant.
Plant, Your Lordship.
Okay.
From which, Your Lordship,
Maherpur Water Supply Scheme Plant. Okay.
yes, Your Lordship. From the said plant, Your Lordship, all continuously dirty water and sludge enter into the petitioner's land, Your Lordship, and the petitioner has constructed a G+1 building, Your Lordship, and in the ground floor he has been running his furniture shop, Your Lordship, and because of the entrance of the dirty water and sludge, Your Lordship, his shop always being filled with the water and damaging his building, Your Lordship. A petitioner submitted sent a legal notice, Your Lordship, and in response to the legal notice, Your Lordship, Executive Engineer PHE, Your Lordship, has submitted his report in page 19, Your Lordship.
Page 19.
Page 19, Your Lordship. And in that said report, it has been admitted that, Your Lordship, that the water has been creating inconvenience. And it was assured that the problem will be resolved soon, Your Lordship. In last paragraph, Your Lordship.
Okay, the exercise which was indicated in page 19 letter,
Yes, Your Lordship.
whether that has been completed?
No, Your Lordship. Thereafter, Your Lordship, petitioner submitted. Even after
retrofitting and separate drain, those are constructed.
Not, Your Lordship. That petitioner, even after the assurance, Your Lordship, petitioner submitted representation also, Your Lordship, page 20, Your Lordship, before the superintendent engineer, Your Lordship, citing his grievance, Your Lordship, and also to the deputy commissioner in page 22, Your Lordship. But field
superintendent engineer would be the authority.
Your Lordship.
Yes, Mr. There was an admission that drain was not in proper, is not in proper slope. which results in suffering of the people of the area.
Yes, Lordship, here there's some factual aspects that will have to be verified, Lordship, and here mostly the compensation that has been sought is
First, he needs a redressal of his grievance. Compensation is different. In compensation, we are not going to give in a writ petition.
I'll take instructions, Lord.
Otherwise, you take the recourse as per that. Consider his representation.
Yes, your lord. That will.
That can be done also. Yes.
Within a period of 45 days.
Yes.
Try to resolve.
Yes.
As per suggestion given by this executive officer.
Yes, that can be done, Lord.
Yes, your lord.
But Mr. K. Mira, learned counsel for the petitioner. And Mr. I. Thakur,
Yes, Lord.
learned counsel, training counsel.
On behalf of standing.
Learned counsel representing Mr. Ian Gusar, learned standing counsel, Public Health Engineering Department for the respondent number 1 and 4. 1, 3, and 4, and Mr. M.S. M. Borma, Junior Government Advocate, Assam for the respondent number 2. Full stop. And the petitioner, in this petition, the petitioner has averred that he is the owner of a plot of land measuring 2 kathas, 12 chotaks, covered by dag number 1200 and patta number 412, phase 2, located at, situated at which place? Moza Ambikapur. Where is that area? What is the area? You have written only Moza. Hmm?
It is in Ambikapur part 10.
Situated at Ambikapur, part Roman 10. That is Moja. Perhaps Meherpur. Meherpur, perhaps, or what? A village, Alitikar. Kama Meherpur. Moja, Ambikapur, part Roman 10, district Kachar. The petitioner has asserted that he is in occupation of the subject plot, whereon an RCC building, whereon he has constructed an RCC building Z+1 after obtaining permission from the Silchar Development Authority in the year 2018. The petitioner has further stated that he has been carrying on a business of furniture shop in the name and style of Messrs. Muskan Furniture from the ground floor of the said RCC building, and the petitioner resides with his family in the first floor of the said RCC building. The petitioner has projected that the respondent Public Health Engineering Department has undertaken a water supply scheme that is, Meherpur water supply scheme under the Jal Jeevan Mission in the plot adjacent to the in a plot adjacent to the subject plot, belonging to the petitioner. Full stop. The petitioner has alleged that the plant, the Meherpur water supply scheme plant, has been installed in the said adjacent plot without proper drainage facilities. As a result, the sludge, as a result, sludge, and the contaminated water used to escape from the adjacent plot into the petitioner's into the subject plot belonging to the petitioner. Full stop. As such, sludge and contaminated water enter into the subject plot often. The petitioner has been facing difficulty in running his business from the ground floor of the RCC building, apart from the difficulties faced in staying in the first floor of the said RCC building. Full stop. When Mr. Mira, learned counsel for the petitioner, has submitted that a notice was served by the petitioner on the respondent number 3 on 3/6/2022, highlighting the above incidents and on receipt of the said notice, the respondent number 3 caused an inquiry through the respondent number 4 full stop. The said inquiry was initiated by a letter dated 9/6/2022, whereby the respondent number 4 was asked to submit a detailed report regarding the complaint lodged in respect of the Meherpur water supply scheme. Full stop. Mr. Mira has further drawn attention to the report of the respondent number 4 submitted before the respondent number 3 on 14/6/2022 to submit that the respondent number 3 in his said report has reported that during backwash, water of large drain in connection with the Meherpur water supply scheme overflows and drifts towards the public drain as the outlet of the drain constructed in connection with Meherpur water supply scheme is not in proper slope, and the same results in suffering of the people in the area. Mr. Bottakul, Council appearing for the respondent PHE Department Authorities has submitted that the report of the respondent number 4 has indicated, has suggested certain measures to redress the issues connected with the Moharpur water supply scheme. Mr. Mira has further submitted that the representation submitted before the respondent number 3 on 22/8/2022 has not been given due consideration till date, nor the respondent number 3 has undertaken any exercise in terms of the report dated 14/6/2020. What I would do. I have heard, having considered the submissions of the Learning Council for the parties, having gone through the materials documents annexed to the petition, more particularly, the report of the respondent number 4, submitted on 14/6/2022, it is noticed that it is not in dispute that the petitioner has plot of land subject plot belonging to a petitioner is adjacent to the plot of land wherein the Meherpur water supply scheme has been installed. From the documents annexed to the petition, more particularly, the report dated 14/6/2022 of the respondent number 4 submitted before the respondent number 3 on 14/6/2022, it has emerged that though the Meherpur water supply scheme has been installed with its own sludge disposal system with sludge pond, sludge water from sludge drain overflows and drips towards the public drain sometimes during backwash, as the outlet of the drain, sludge drain, is not in proper slope, and as a result, the people in the area has to suffer due to such overflows of sludges. The report has further suggested that the works for retrofitting of Meherpur water supply scheme was undertaken under the Jal Jeevan Mission and separate drain had been included in the retrofitting works. Full stop. It was indicated in the said report that once the retrofitting works, including separate drains, suggested that once the works of retrofitting and construction of separate drain will be completed, the problem suffered by the people in the adjoining area, including the petitioners, could be resolved. Full stop. As it is submitted on behalf of the petitioner that the works of retrofitting and construction of separate drain for the purpose of redressal of the grievances and suffering of the people in the area in connection with Meherpur water supply scheme have not been resolved till date, and the representation of the petitioner before the response number 3, representation of the petitioner submitted on 22/8/2022, have not been given due consideration till date, this petition, has agreed to by the Land and Council for the parties, is disposed of with a direction to the response number 3 to examine and consider grievances expressed by the petitioner in his representation dated 22/8/2022 and to take action in terms of the report dated 14/6/2022 submitted by the respondent number 4 so as to redress the grievances and sufferings, so as to redress the grievances of the petitioner. Full stop. Such exercise, it is observed that such exercise shall be completed within a period of 45 days from the date of submission of a certified copy of this order by the petitioner at the office of the respondent number 3. Full stop. The decision so taken, it is further observed that the decision and any decision so taken shall be communicated to the petitioner forthwith thereof. Full stop.
Item number 16.
My lord, my 10 acres TB land along with tea stall were acquired by the National Highway Authority in the year 2011. Similar persons have been provided the compensation, but I have been denied, though I approached the authority several times.
What I'll object, because this here said, it is not, this is Toji Bahil, Bahira land. There's a meaning there where it is a not Patta land.
But my lord, similar
persons given,
similar persons given, no supporting document, nothing. No, any lordship, not first day, if your lordship, whatever. I do it needful.
M.U. Mahmood, Land and Council for the petitioner, who are Ministry of Transport, Central Government, yes, Mr. Mehdi,
Oh, yes.
Mr. Borua, you appear for one also, no?
No, 2 and 7, my
Mr.
lord.
P. Medhi. P. Medhi, right?
Yes, sir. PK Medhi.
PK Medhi, Lana Central Government Council for the respond number 1. Mr. C. Borua,
2 and 7, my lord.
Learned Standing Council, National Highway Authority of India. For the respond number 2.
And 7.
7. MS N. Bordoloi, Learned Standing Council, Revenue and Disaster Management Department for the respond number 3. MS M. Morgan, Learned Junior Government Advocate Assam for the respond number 4, 5, 6. And any stand PWD. Mr. B. Gogoi, Learned Standing Council PWD for the respond number 8. The petitioner has stated that he was in possession. You cannot be owner then if it is a government land.
Yes.
You cannot be owner.
But in the text receipt, I have been written as owner. Can you
No,
see
cannot be.
page 21?
No, merely because he was in possession of a plot of land measuring 10 lesses,
Along with
comma, covered by BJ Patta number 23, comma, in lot number 13, village Garoleti, circle
Manipur.
within bracket, erstwhile Bizni, district Bongaigaon, Assam. Full stop. The petitioner was running a tea stall from the said plot of land. Full stop. The said plot of land came to be acquired by the respondent NHAI authorities for the purpose of construction stroke widening of National Highway number 31. Full stop. It is a grievance of the petitioner that despite acquiring the said plot of land from the petitioner has not been paid any compensation. Full stop. The petitioner has sought to draw similarity with two other persons.
Yes.
Namely,
Tiken Nath and
Tiken
Ramkrishna.
Nath and Ramkrishna Nath is to submit that though the said two persons were also in occupation of government plot of land paying Bedokoli Jorimana, the said two persons were disbursed compensation in connection with the acquisition process, but the petitioner has been deprived of the land of the compensation amount despite being similarly situated with the said two persons. Issue notice returnable in 4 weeks as so and so appeared, accepted, no formal notice, extra copies within 2 working.
All right.
Huh?
There is a typographical error while responding to the government of India.
It is corrected here in your copy. To get it corrected, Assam. Instead of India, it is Assam.
Item number 17.
This is regarding forest royalty. Payment of forest royalty before while applying for building permission.
Lordship, even though we have been implemented as respondent 1 and 2, the parent notification as well as the impugned letter are both issued by Mines and Minerals Department, Lordship.
Oh, they are parties or not?
They are.
Yes, they are parties.
You are constructing some structure in your own land or what?
Own land. I'm a private individual.
Private individual seeking to construct in his own plot of land. Similar order was.
Yes, Lordship.
Passed earlier. Let us. Asani. Passes.
Uh, 4070. 2040.
The heart is the D. Borua. D. Borua. Planet Council for the petitioner. Mr. I. Botakur. Planet Council representing Mr. P. N. Goswami. Standing Council Forest and Environment Department for response number 1 and 2. Housing Urban, Mr. Bora.
3 and 6.
Mr. S. Bora, Lion Standing Council, Urban Affairs.
Housing urban.
Housing and Urban Affairs Department. And
6.
GMC for the response number 3 and 6. MS M. Bormon, Lion Junior Government Advocate Assam for the response number 4 and 5. The petitioner has averred that he owns and is in possession of a plot of land measuring 3 kathas, covered by DAG number 617 within bracket new and KP Patta number 1857, situate at Revenue Village Borhojai, Mauja Beltola, Dispute Revenue Cycle, Kamrup Metropolitan District, bracket of subject law. Full stop. It is a case of the petitioner that petitioner is desirous of constructing RCC building on the subject plot and has accordingly, sought to proceed for obtaining building permission stroke no objection certificate within bracket NOC online for construction of such building after taking loan from financial institutions stroke bank. The petitioner has averred that he intends to construct the proposed building by obtaining the materials from open market, by paying all due necessary taxes, etc. But the petitioner has been informed, it has been informed to the petitioner that the building permission stroke NOC for construction of the proposed building would not be granted unless the petitioner deposits forest royalty in terms of a decision taken by the Mines and Minerals Department, Government of Assam, contained in the communication bearing number PEM 174 336 stroke 183 dated 2/3/2023. Annex 4. Full stop. Official লিখে দিব 2.1 to আছে issue notice 3. All respondents 4. Five and 6. Similar order.
Matter listed along with WPC number 204023.
There are so many. Go one time.
My lord, our name may be shown and.
The name of Planet Government Advocate
Will be given to us, my lord, as we don't have the.
Assam be reflected in the respondent side in the call list.
3 copies may be.
Extra copies. Okay, 3 copies to MS Gorman.
Item number 18.
May it please before the lordship. In this case, my lord, we have challenged the order dated 10/12/2003.
10/12/2003.
23, sorry, my lord. annexure 5 at page 58.
58.
58, my lord, on the ground that the same has been passed in complete.
Let us read a show
Com-
cause.
Complete violation of principle of
58.
electoral justice, my lord.
Let us read.
Please, 58,
Show
my
cause
lord.
notice statement referred to was issued to you
Under
under section 73. 73 of the GST Act.
GST Act, my lord. GST Act.
For the region stated therein. Where is this, where is that show cause notice? Page?
So cause notice is, my lord, at page 28, my lord.
Okay. Since no payment has been made within 30 days of the issue of the notice by you, therefore, on the basis of the documents available in the department. Any- Okay.
Then, my lord, the so-called notice was issued on 28/9/2023, annexure 2, my lord.
Annexure
2 at page 28, my lord. Before coming to the facts of the case, my lord, I would like to place the relevant section of the some
Okay,
general
okay.
sales
Let
tax.
me read, then we'll go to the provision.
Page 28,
What
my
is
lord.
this summary?
This is summary of so-called notice, my lord.
Taxpayer has filed GSTR 9.
Next page, my lord, 20.
One. Okay, next page.
Next page, my lord, 29. Middle of the page, details of personal hearing and due date of to file reply. Date by which reply has to be submitted, my lord, 28/10/2023. And date of personal hearing and time and venue, my lord, not applicable. The opportunity was not granted for hearing, my lord. That I wanted to show. This next page, my lord.
When did you submit your reply?
I submitted my reply on, my lord, on 9/12/2023 at page, my lord, 41.
It was otherwise indicated as 28/10/2023.
Yeah, on 28, my lord, I filed one petition for extension of time.
Okay, it was granted.
No communication was received. That is, my lord, annexure 3. Annexure 3 at page 38, my lord.
When did you submit it?
It was uploaded in the portal, my lord.
When?
28/10/2020.
Okay, by the time.
Yeah, by within
time.
Within time.
Okay.
Thereafter, no communication was received. Finally, my lord, I submitted reply on 9/12/2023, annexure 4 at page 41, my lord.
To 1 minute, what is it? Adjournment. This was page 38 was the adjournment.
This adjournment, my lord.
Adjournment for submission. That was uploaded.
Yes, my lord. This is the receipt at page 31. And
31.
38, my lord.
This is a receipt.
This is the acknowledgement of the submission, my lord. Petition is on next page.
Okay. Then,
my lord, on
9/12.
9/12, I finally submitted my reply. 9/12, annexure 4 at page 41, my lord. The petition is on the next page, what I submitted. This is the submitted in detail, my lord, containing 7 pages along with annexures, supporting documents. Then, my lord, the very next day, one more thing, my lord, at page 41, please, my lord. Page 41, serial number 7, my lord. Option for personal hearing. I choose for the personal hearing. Then, my lord, at page 48, my lord. Clear portion of my petition, page 48. Under the facts and circumstances stated above, we request your honor please to drop the proceeding under section 73 of the Assam Goods and Service Tax Act 2017 for recovery of tax amounting to rupees so and so for the ends of justice, otherwise we shall be put to so and so. Next para, my lord. In case you decide not to drop the proceeding, we request you please to grant us opportunity of personal hearing so that we may satisfy you with regard to the submissions made above.
Now, in the order, that is page 58,
58,
whether there was any mention of your
no, nothing mentioned. my lord.
reply?
The very next day order was
No,
filed.
no. Whether was there any mention of your reply?
No, my lord.
Nothing.
They have said only since no payment has been made within 30 days of the issue of notice by you, therefore, on the basis of documents available with the department and information furnished by you, if any demand is created for the reasons and other details and attached in annexure.
Where is the summary of so-called notice?
Summary of so-called notice is at page, my lord, 28, my lord.
But this page 30 is part of that.
Then of the order.
Oh, no. Page 30 is
30.
part of page 28.
Yes, my lord, 28, part of 28. Yeah, various tables have been stated there, have been given in the table, my lord, saying why the demand is proposed to be made. But in the order, nothing has been mentioned, my lord. My submission has not been considered.
Yes. Okay, then?
Then, my lord, in the page 59, my lord will come to last para. You are hereby directed to make the payment by 10/1/2014, telling which proceedings shall be initiated against you to recover the outstanding dues.
Now, what is the violation you have alleged?
I have alleged that this order has been passed in complete violation of principle of natural justice, my lord. The Act section 75(4) of the GST Act, my lord. It is a mandatory provision, my lord. May I read, my lord?
74.
75, subsection 4, my lord.
75.
Subsection 4.
1 minute.
An opportunity of hearing shall be granted where a request is received in writing from the person chargeable with tax and penalty, or where any adverse decision is contemplated against such person. Word shall has been used, my lord, in this.
1 minute. Yes.
Lordship, if Lordship compares the show cause and the demand notice, in show cause notice, Lordship, page 29, the total due has been stated to be 7,73,072. And in the demand note, Lordship, page 59, it has come down to 5,25,000.
Okay, some
Some
relaxation has been granted. That does
some
not-
has been taken into account in response to the
But question is,
reply.
where is that discussion, anything about this, their reply to so cause?
Lordship, it appears that that was taken into account because the first paragraph, page 58, Lordship.
People are writing 10-page so cause reply for nothing.
Lordship, it
There
says
should
that
not be any reflection of whatever is suggested by the SSC. That request. rejection. And rejection requires reflection of region, disclosure of region, so that assessing authority has applied his mind, at least to some semblance,
Dear Lordship,
some semblance. The second part, that he has asked for a specific request, that personal hearing.
that has
And-
not been reflected.
And
Lordship.
the order is adverse to him. Secondly, he has asked for personal hearing specifically. This is a mechanical kind of.
Lordship, at this stage, notice may go,
Oh,
Lordship.
pardon.
No coercive action that may be
That-
given, Lordship. In the meantime, I'll.
That
have-
page, come to page 59. After the table. Don't
Yes,
check
Lordship,
this.
you are the make payment by 10-1.
There shall not be any proceeding to recover any outstanding due in terms of this notice.
Lordship, no coercive action in terms of this.
This is specific
non-notice.
because I have privacy. I am satisfied that personal hearing was not afforded. There is no disclosure of reason. At least adjudicating authority must record some reason as to why the reason cited by the SSE in his reply to show cause notice does not deserve acceptance. Those are missing.
Lordship, it's software
And so
generated.
for personal hearing,
It appears, Lordship.
that is violation of nature justice.
Lordship, notice my.
So far, non-recording, that can be a ground for appeal. But so far as violation of the principles of nature justice.
That is there, Lordship.
Okay, no coercive action till the next date. Heard Mr. R.K. Joshi.
Yes, madam.
Learned counsel for the petition. And Mr. B. Chaudhary, Learned Standing Counsel, Finance
All the respondents.
Department, Assam, for all the respondents. Full stop. And petitioner is an SSC under the Goods and Services State
Yes,
State Goods and Services Tax, which registration Assam Goods and Services Tax Act 2017, having registration number para 3 number applicable. The petitioner was served with a summary of show cause notice dated 28/9/2023. Wherein it was alleged that the petitioner, no, anomalies were observed in returns submitted for the tax period July 2007 17 March 2018 to the extent of rupees 7,73,072. The show cause summary of show cause notice was served by the respondent number, was issued by the respondent number 3. Full stop. On receipt of the notice dated 28/9/2023, the petitioner had initially submitted an application on 28/10/2023 seeking extension of time to submit his reply to the show cause notice by uploading it in the portal. Full stop. Thereafter, the petitioner submitted a detailed reply to the show cause notice on 9/12/2023, making specific request for personal hearing. Full stop. The reply to the said show cause notice was uploaded in the portal on 9/12/2023. Full stop. Immediately on the next day, the impugned order under section 73 has been passed by the respondent number 3, foisting a liability upon the petitioner to the extent of rupees 5,25,806. Full stop. The impugned order has further mentioned that the petitioner should make payment by 10/1/2024, failing which proceedings shall be initiated against the petitioner to recover the outstanding dues. First, Mr. Joshi, learned counsel for the petitioner, has submitted that there is no recording of region in the impugned order dated 10/12/2023 in respect of the submissions made by on behalf of the petitioner in the detailed show cause reply to the show cause notice dated 9/12/2023. Full stop. He has further submitted that in the detailed reply to the show cause notice, the detailed reply dated for 28/10/2023 to the show cause notice. The petitioner had asked for personal hearing in terms of subsection 4 of section 75 of the GST Act 2017. But while passing the impugned order dated 10/12/2023, after submission of the detailed reply on 9/12/2023, the petition was not afforded any personal hearing, and the same is in clear violation of the provisions of subsection 4 of section 75 of the GST. Mr. Chorvil, Standing Counsel, Finance Taxation Department, has sought for some time to obtain instructions in the matter. Issue notice returnable on. Yes, when? 5/2?
Yes.
Or 12/2? 12/2/2023. It is noticed that the petitioner submitted a detailed reply on 9/12/2023 in response to the show cause notice dated 28/9/2023. After making a prayer for adjournment, after making a prayer for extension of time to submit detailed reply on 28/10/2023. Also, in the detailed reply dated 9/12/2023, the petitioner had specifically asked for an opportunity of personal hearing. As per subsection 4 of section 75 of the GST Act 2017, an opportunity of hearing is to be granted where a request is received in writing from the person chargeable with tax or penalty, or where any adverse decision is contemplated against such person. Full stop. Having regard to the facts projected in this petition by the petitioner and the provisions contained in subsection 4 of section 75 of the GST Act, is provided the petition, the court is of the primacy view that the petitioner has been able to make out a primacy case for an interim relief. Full stop. It is according, provided that till the next date of listing, there shall not be any coercive action by the respondent authorities by initiating any proceeding against the petitioner to recover the alleged outstanding dues in terms of the impugn order dated 10/12/2023. Extra copies, did you? By tomorrow. By tomorrow. Okay.
This petition has been preferred, my lord. Praying for issuance of a direction to the respondents, my lord. Praying for direction of the issuance of a direction to the respondents, my lord, to cause an inquiry over the Tarabari PS case number 244/2021, my lord.
Which show is affair?
My lord, this is a page, my lord. Where it's 26, my lord, page 26.
Your brother?
Yes, my lord. Actually, my lord, the petitioner's family does not belong to the SC community, my lord. His father, my lord, somehow obtained 2 certificates in the name of the petitioner as well as the respondent number 9, my lord.
You are 60 years.
Yes, my lord. The petitioner's certificate has
When
been
did you
surrendered.
obtain?
The petitioner's
When did
certificate
you
has been-
obtain this?
the petitioner's father, my lord, obtained. After coming to know, my lord, he has surrendered his certificate, my lord, and requested the respondent number 9, my lord, his younger brother, my lord, to surrender.
So
his
did you submit any application under
Yes,
156.3?
yes, my lord, yes, my lord.
156.3?
Yes.
No, nothing.
Representation, my lord, before the DC, my lord, Borpeta, my lord. And upon
So you want investigation of this case?
representation, my lord, and hearing
You want investigation of this case?
Yes, my lord.
Then writ petition is not a
See, my
proper
lord,
remedy.
the DC, my lord, the additional deputy commissioner of Borpeta, my lord, has issued a letter, official letter, my lord, by which the circle officer, Sengar Revenue Circle, was directed to conduct an inquiry over the matter, my lord.
What is, how your writ petition has been structured?
Yes, my lord.
Kindly
Kindly
proceed with the
page
investigation.
22, my
We
lord.
are at page 12, my lord.
Investigation.
Legal
As per
opinion
law.
request.
As per law, my lord.
Then
Thereafter, my lord, the petition was issued a certificate.
writ petition, I don't think.
My lord.
Yes, my
second
lord.
question.
Kindly see
You
the,
approach 156.3.
kindly see the page number 22, my lord. Kindly see page number 22, my lord, and it's E, my lord.
So what do you want? Investigation. Then writ petition is not maintainable.
Investigation,
You take recourse to 156.3.
non-action, my lord, on the part of the respondents, my lord.
No,
Despite of the fact
one
that
is
several office letters.
Mr. Counsel,
Yes, my lord. The several office letters.
several occasion will not see. If you want investigation of this case to be done as per law, then it has to be
156.
first that you have to approach and take recourse to 156.3.
Thereafter, my lord, kindly see the, my lord, page
We are
number.
not entering.
My lord, page, my lord.
We are not into it. If this kind of writ petitions are to be entered in,
Page 33, my lord.
despite appropriate remedy,
Kindly
no.
see the page 33, my lord.
We'll not go into that. You take recourse to 156.3. What is your case? Your father obtain SC certificate.
Yes, ma'am. In the name of the petitioner as well as the respondent number 9, ma'am.
And what did you do with your caste certificate?
I have surrendered my certificate.
You have surrendered.
Yes, my lord. As because my lord, we do not.
And what job this respondent is doing?
My lord, government job, my lord. My lord. In the Gale, my lord.
Hmm? In Gale.
Yes, my lord.
So you want action against him?
Yes, my lord. Otherwise, my lord.
Relationship has become sore or what?
Yes, my lord.
That is why.
Yes, my lord. The petitioner has been out
Hard,
from his house. my lord.
Mr. S. Islam. Learned counsel for the petitioner.
And this is just notice may go, my lord.
No notice. Absolutely not. You have another recourse, you take recourse to that. You want investigation only.
Investigation as well, my lord.
I'm directing.
Yes, my lord. No action has been taken
And Miss
from the end of the
Mormon.
PC, my lord. Although my lord,
Learned
hearing was conducted, my lord.
Junior government advocate for the respond number 1 to 7. Full stop. Considering the nature of relief sought for and the statements and averments made in this writ petition. The repetition is taken up for disposal at the admission stage itself. Full stop. In this writ petition, instituted under Article 226 of the Constitution of India, the petitioner has averred that the family of the petitioner does not belong to any reserved category like scheduled caste. But the father of the petitioner your father obtained also caste certificate?
No, my lord.
But the father of the petitioner obtained caste certificates in favor of his two sons, that is the petitioner and the respondent number 9. When? Any idea?
There is a date, my lord. Date cannot be, my lord. Certain.
From the respondent number?
Respondent number 8.
By presenting distorted facts and as a result, caste certificates were issued in favor of the petitioner and the respondent number 9, showing them that they belong to scheduled caste. Full stop. Though the petitioner has surrendered the caste certificate, put in back a scheduled caste. The petitioner, the respondent number, the petitioner has stated that though he had surrendered the caste certificate, put in bracket scheduled caste, the respondent number 3 continued to avail the benefits under the said caste certificate illegally.
Number 9, my lord.
9. Full stop. It is the further case of the petitioner that the respondent number 9, by availing the benefits under the caste certificate within bracket scheduled caste, had also obtained a job, and as on date, comma, he is serving in a any details? No. No details.
No details.
He is serving in a government opportunity. He is serving obtained government job and has been as on date, comma, he is serving. So Mr. Staff Learned Counsel for the petitioner has submitted that the respondent number 9, comma, has been serving in GAIL Gas Authority of India Limited. Full stop. When efforts, when representations submitted before the respondent authorities, including the Deputy Commissioner Barpeta, did not bring the desired result as regards cancellation of the caste certificate, scheduled caste, issued in favor of the respondent number 9, comma, the petitioner submitted the first information report on full stop, submitted alleging inter alia that first information report against the respondent number 9, alleging inter alia that the respondent number 9 has been serving in GAIL by showing a fake caste certificate within bracket scheduled caste. So, on the basis of the said FIR, comma, a crime case, comma, Tarabari Police Station case number 244, 2021 has been registered for the offences under sections 420, 468, 471 IPC on 2/11/2021. Full stop. Where the petitioner has, in this state petition, comma, the petitioner has alleged that despite registration of Tarabari Police Station case number so and so, the respondent number 7 has not proceeded with the investigation of the case in a manner desired, and as a result, comma, no action, no discernible steps were found to have been taken resulting in a lackadaisical and perfunctory in investigation. With such allegation, the petitioner has instituted the instant writ petition, seeking entirely a direction to the respondent authorities to proceed with the investigation as per law expeditiously. Full stop. Para 4. Para 5. Para 6. Para 7. In view of the above fact situation obtained in the case, as have been projected briefly above, and in the light of the observations of the Honorable Supreme Court of India in Sakiri Basu Supra and Sudhir Bhaskar Rao Kambe Supra, this writ petition seeking the above direction is not entertained, however, reserving the liberty, however, to the petitioner to avail the remedy of approaching the jurisdictional magistrate under section 156(3) CIPC, if so advised. While not entertaining the writ petition, this court would like to clarify that this court has not expressed any opinion on merits and whether any cognizable offense is made out or not. Taking cue from M. Subramaniam and another Supra, it is also clarified that null. If this kind of writ petition is to be entertained, then High Court will be flooded with thousands of writ petitions. That is the observation.
Lordship, Mr. Esbora is on late. Let the matter be taken after some time.
What is the case?
But here the petitioners are not four flat owners of residential apartment. But there are lot many deviations that we have represented to the GMC authorities, lots, because parking place, children playground area has been earmarked as parking lot and illegally allotted. Then the construction has been carried out at the basement. My lord, kindly see page 39. But at this stage, I am praying for notice, my lord. Let them respond. They are not responding at all.
Well, you should notice at this stage then.
Yes, my lord.
But Mr. R. Dubey, learned counsel for the petitioners. MS
J. Rajkumar.
J.
Rajkumar.
Rajkumari, learned counsel, representing Mr. S. Bora, standing counsel ZGD and GMC. For the respondent number 1 to 4. Full stop. The petitioners your prayer is limited.
Yes, my lord.
So, to act upon the representation,
my lord, and conduct an inquiry, my lord. If your lordship would see my prayer at page
17.
Yes, and in the
Can be disposed of otherwise.
Let respondent number 5 comes, my lord.
Because otherwise they have to issue notice.
Yes, they have to follow their process.
Procedure.
My lord, we dispose of also, my lord.
If Mr. Bora comes,
Yes,
there is Mr. Bora.
But twice, my lord, we submitted a representation, then reminder.
There are two representations, my lord.
Where is your representation?
Page 38, my lord.
Which is more elaborate?
No, 38 is the first one. Second one is the reminder.
Okay, 38 basically.
Let it be both together, my lord, because new facts have been added.
And who are you? Okay.
We are the flat owners, my lord.
It is the case of the petitioners, comma, 4 in number. That they purchased flats in a multi-storied RCC building constructed by the respondent of 5. The said multi-story building is situated at NS Road, Kota Hill, Guwahati. Full stop. Though the petitioners had purchased the flats after from the respondent of 5 by executing registered sale deeds, which provided for certain facilities.
Yes, amenities
and amenities, comma, the petitioners were deprived of the said amenity facilities and amenities. Full stop. Mr. Learned Counsel for the petitioner has submitted that there were lack of adequate parking facilities.
But what has happened, they have illegally increased the parking lot. My lord, kindly read page 39, 1, 2, 3, 4. My grievances.
So after, despite the
Allegation of
it has
illegal
come to the knowledge of the petitioners that the respondent number 5, while constructing the RCC building, and also after completion of construction of the RCC building, multi-story, made blatant violations of the permission granted by the respondent GMC, respondent Guwahati Municipal Corporation. Full stop. Mr. Dubey, Learned Counsel for the petitioner, has submitted that as per the approved plan, comma, there was no provision for construction of any room at the basement or on terrace of the building. Full stop. But the respondent number 5 has illegally constructed 10 number of rooms in the basement and 2 number of rooms on the terrace. And thereafter, comma, sold the same to some third parties in violation of the to third parties. Full stop. Mr. He has further submitted that the respondent number 5 had illegally increased the number of parking spaces in the said RCC multi-story RCC building, and even use the area sanctioned as children's play area for construction of parking spaces, and has also sold off the same to some third parties. Full stop. He has submitted that highlighting all these illegalities and deviations, the petitioners had submitted a representation before the respondent number
3, my lord.
3 on 23/5/2022, followed by a reminder on 5/9/2023. Full stop. The grievance of the petitioners is that despite bringing all the illegalities and deviations committed by the respondent number 5, the respondent authorities in the GMC have not given due consideration to the representations dated 23/5/2022 and 5/9/2023 till date, as no discernible steps to address the grievances of the petitioners are found to have been taken. Mr. Alleging inaction on the part of the respondent authorities. Such inaction on the part of the respondent authorities in the agency, the petitioners have approached this court by instituting a writ petition. So, Mr. Bora, standing also GMC, has submitted that since the petitions have already highlighted their grievances by stating the alleged illegalities and deviations in respect of the construction of the multi-story RCC building before the respondent number 3. The same deserves due consideration to stop, since the petitioners have alleged that the representations dated 23/5/2023 and 5/9/2023 have not been given due consideration till date, the petition can be disposed of at this stage with a direction to the respondent number 3 to take the representations on board and to examine the veracity of the alleged irregularities and deviations in respect of the construction of the multi-storied building by the respondent number 5. Mr. Dubey, learned counsel for the petitioners, have submitted that the petitioners shall also be afforded opportunities of hearing before the respondent number 3. And to submit supporting materials in support of their contention as regards the alleged irregularities and deviations. First of, in view of the projections made on behalf of the petitioner in the posted manner and the submissions, having regard to the submission made by Mr. Boral and counsel for the petitioner, this court is of the considered view that instead of keeping this writ petition pending, and considering the fact that the representations dated so and so have not yet been disposed of by the respondent number 3, this court is of the considered view that instead of keeping this writ petition pending, the same can be disposed of with the direction to the respondent number 3 to take the representations submitted by the petitioners, on so and so and on so and so on board, to consider the grievances of the petitioners as regards the alleged illegalities and deviations committed by the respondent number 5 in construction of the multi-story RCC building on the reference. It is further observed that the such exercise, such consideration shall be made as per by taking into considerations the provisions of which act?
The GMC Act and the bylaws.
The GMC, the Guwahati Municipal Corporation Act
1971.
1971, and the bylaws. And the
Building bylaw, there are.
and the building bylaws construct framed under it. It is further observed that while undertaking the exercise, due opportunities of hearing and also to submit supporting materials should be afforded to both the sides, that is the petitioner side and the respondent number 5, after issuance of due notice to them for their appearance. As the matter might require, as the exercise might require field inspection, this court is of the view that such exercise shall be completed within a period of 2 months. 2 months from the date of submission of a certified copy of this order by the petitioners at the office of the respondent number 3. This disposes of the repetition.
I'm deeply obliged.
Binding item number 7.
7. Yes.
Lordship, here the eviction order was actually passed after a detailed verification.
Long back.
Yes, and the petitioner has already been evicted. Also, Lordship.
Evicted?
No.
We don't know about that, but there is a representation at page 39. You can consider that. We don't know what is happening at the ground level.
Yes, status quo.
39. We are not making any status quo order.
Lordship, the deed that also they are relying on, that is.
These are family.
Yes.
Family deed.
Yes.
They are dealing with forest land by way of a family deed.
Yes,
We are not
that-
taking cognizance of it.
Yes. That
We are not
should
taking
be-
cognizance of it. They are as if they are distributing forest land as per their own wish and
There is
desire.
no heritable right, Lordship.
We are not taking
We are
cognizance
also
of it, but any view of the matter, there is a representation you may consider.
Yes.
We are not
If the forest because they
giving
take
any
away.
status quo order.
That may be done, Lordship. Although, Lordship, I would point out that this eviction order was passed after a report by.
I have seen it.
Yes.
But without
I
hearing.
have seen it. Whatever their claim as regards original land allotted to Miss late Abdul Aziz,
Yes.
These are family matters we are not entering into, but regarding their representation, take a call.
Yes, that can be done.
The call can be taken by whom?
Respondent number 3, Your Lordship.
DFO.
DFO.
DFO has said.
Heard Mr. R. Mojumdar, Learned Counsel for the petitioners. Petitioner. Full stop. And Mr. I. Portagut. Learned. Standing counsel. Forest and Environment Department. For the respondent number 1, 2, 6. Full stop. The petitioner has projected that one Abdul Aziz was his predecessor and his grandfather. Abdul Hadi Aziz had 2 sons, Asadul Jaman and Rosid Ali. Full stop. Abdul Aziz, according to the petitioner, Abdul Aziz was allotted a total of 31 bighas by the respondent authorities. Total 30 bighas of land at old and new Korabad Forest Village within bracket FB by the respondent authorities, and the successors in interest of Abdul Aziz, Asarul Jaman and Rosid Ali are in occupation of the said 31 bighas of land till date. Full stop. From the case projected in this petition, it transpires that the dispute is with regard to
3 bighas.
respective occupations of the family members, 2 branches, family members of the 2 predecessors, Asarul Jaman and Rosid Ali. Late. Full stop. Clara. On representations being made, from the petitioner's side, an inquiry was directed by the respondent number
3.
To the respondent number
4.
On 22/10/2019. Full stop. The respondent number, after inquiry, the respondent number 4 has submitted a report on 24/3/2021, reporting inter alia to the effect that the petitioner side have been enjoying occupation in respect of 2 plots of land measuring Roman 1 8 bighas, 12 kathas, 0 chataks, and Roman 2, 5 bighas, 0 kathas, 0 chataks. And the members and the lineal descendants of late Rashid Ali had been enjoying occupation of 17 bighas, 10 kathas, 0 sataks. Full stop. The report has further indicated that the petitioner side had forcefully encroached an area of land measuring about 3/4 bighas in the said forest village, covered by DAG number 30. In said forest village, in old Koirabad forest village, under DAG number 30. Though the allotment in respect of the said area of land was made in favor of late Rashid Ali. Full stop. The petitioners have controverted the said finding made in the inquiry report dated 24/3/2021 by contending that the said area of land measuring 3/4 bigha or covered by DAG number 30 at Old Koirabad Forest Village was handed over to the petitioner side by the side of by the lineal descendants of late Rashid Ali. Full stop. Clara. The report dated 24/3/2021 was followed by an order dated 27/9/2023, whereby of the respondent number 4, whereby
Five and six. Respondent number
respondent number 5 and the respondent number 6 were asked to carry out eviction in respect of
3 bigha land.
the disputed area of land covered by DAG number 30 at Old Koirabad Forest Village. Full stop. Agreed by the issuance of the letter order dated 27/9/2023, whereby the petitioner's side was sought to be evicted, the petition side had prepared a representation before the respondent number 3 on 17/11/2023, claiming that they were in bona fide occupation of the said disputed area of land covered by DAG number 30 at Old Koirabad Village. Full stop. Though Mr. Mojumdar has submitted that the petitioner side is in occupation of the said disputed area of land, Mr. Bothakur, Learned Council representing the respondent Forest and Environment Department authorities has controverted the said submission. Full stop. Since the matter of possession of the area of land measuring 3 acres covered by DAG number 30 at Old Koirabad Forest Village is a disputed one, this court does not require to embark upon a fact-finding exercise. Since the petitioner side has already submitted a representation before the respond number 4. Three on 17/11/2023, which is stated to be pending, this court is of the view that the respond number 3 shall consider the seat representation regarding the claim of the petitioner side in respect of the area of land covered by measuring so and so, covered by DAG number so and so, at so and so, by taking into accounts the relevant records as well as possession of the respective sites. After hearing both all the stakeholders by issuance of for undertaking such exercise, the respond number 3 shall ensure that opportunity to afford opportunity of hearing to all the stakeholders, including the side
Respondent number.
lineal descendants of late Rashid Ali, more particularly, the respond number
8 to 10.
8 to 10, impleaded hearing. So stop. In view of such direction, this no notice is required to be issued. No notice has been issued to the respond number 8 and 9. So, the entire exercise shall be completed within a period of 6 weeks from the date of submission of the certificate of disorder by the petitioner and the office of the respond number 3.
Your Lordship, status quo will do no harm, Your Lordship.
No,
If they have not carried out, Your Lordship.
We don't know.
Yes, that's why status quo,
there's-
Your Lordship.
There's a specific notice, Lordship, where the ranger was asked to go and do the eviction, Lordship.
They return back, Your Lordship.
We'll
My
exercise,
instruction
you
is-
take the exercise.
If not, Your Lordship.
These are family dispute.
Yes.
You are bringing it to a public domain. Otherwise, we are not interested to entertain.
Yes, Your Lordship.
You are dividing forest land between you by way of a family deed.
The authority is
And
the
you are
DFO.
bringing this to the High Court. We don't think it is a public law remedy.
Only grievance is that
No.
we have not been heard in our petition, Your Lordship.
You will be hard.
Now it will be hard. That's why, Your Lordship.
এইকেইখন দিব না
How many petitioners are here?
Well, 4,
They are tenants.
who are tenants.
The first one is the instructions from the circle officer and next one is the instruction from the OC.
Well, we are tenants.
So Lordship,
under-
may kindly go through the instructions of the circle officer, that is dated 6/1/24, thereafter. If my Lordship go by that para 2, it reflects everything. ইহঁতৰ কিবা এপ্লিকেশ্যনৰ ওপৰত বেছ কৰি আছে কিমানটো নিতে
Demarcation করতে। দখলটো কোনটা দিয়ে না demarcation করতে।
In the second lot, Lordship, that is the report of the OC. Elaborately, he has stated everything, whereby some persons have also been arrested.
Who is Krishan San Gupta? This FIR page 67, who lodged it? Krishan San Gupta.
One of them. Maybe one of them. There were many tenants, Miller.
This page 67, FIR,
The page 68.
that has been registered as, I think, which Bokhista police station, case number 5 of 2024 on 4/1/2024 for section 143, 341, 447, 448, 461, 420, 436, 506. So far that case has been registered at the Bokhista police station.
Yes.
And there was a demarcation case. I think that is by perhaps respond number 6 against respond number 5.
Right.
And so far report says that demarcation was done. Thereafter, they have said that this barricading was, they left the place. Thereafter, this barricading was done. And this is, from the report further says that this is part of a larger scam.
Conspiracy.
Yes, there are other things. Forced registration of the land, not by you, not by respondent 5, but another group of conspirators, land brokers, which has been registered, which land was registered from respondent 5, 6 in another person's name. And his name was deleted. All these, and there are many things.
Different
Many
aspects.
things.
Many things.
Many things. It is not that only respond number 5 and respond number 6. There is which is going on, the scam going on
We're the victim
in
of
the state.
Yeah, we're victim of that scam, my lord.
This
They are not
man
lords,
was
they-
also, his name was registered, his name was deleted, and forced sale deed was registered in another 3 persons' name. All these powerful brokers and all, land brokers, there are many things which is difficult. And so far, in the demarcation case, this man, respondent 5, it appears he did not participate also.
No, my lord, my respectful submission.
No, yes, your submission. Question is then, it is, they are saying that there is no, they had only done the demarcation part. It appears notices are there. So far records are there. We don't know what the veracity of that, but notices were issued to respondent 5, and those parties, he was claiming DAG number 90. DAG number is 90.
90, yes.
90. So demarcation case was initiated, registered. Notices were sent to respondent 5 and respondent 6. Then respondent 5 did not participate, could not be able to produce any document in support of his title ownership as regards DAG number 90. This is what they are saying.
They are saying.
As on date. So demarcation was done, he was not there. Then they left the place. Then thereafter, your man, this FIR was received.
It was registered also.
Page 67, which I have said already. That was received, and accordingly, that case has been registered. And investigation is initiated. The case was registered only on 4/1. 4/1. These are facts. Now, they are not saying that they were involved. There are 3 things will have to be addressed. One is that it might be a case between respondent 5 and respondent 6. He might be a victim of the circumstances. That could be one. If that is so, then that appears to be a civil action. So far, if their involvement is there, state authorities are there in barricading the premises, then it will be a case of state action, high-handed. Those are very difficult as on date to find out.
May I address this issue? My respectful submission is, my lord, for a moment, presume it for a moment, my lord, that these petitioners, being a tenant on that particular plot of land, they were there having shop since 1981. For a moment, presume it, my lord, that they are illegally occupying. And after demarcation, they should leave the place. But in my respectful submission, my lord, this is not the way. They should be removed, they should be evicted by following due process of law. And that protection has not been granted to us. They have given a report very conveniently saying that after we leave, some people went there. Now, tomorrow or today evening, if we go there and remove the barricade, then will the police will not protect us? This cannot be a way of taking somebody's land under possession.
Interestingly, respondent number 5 did not conspicuously take part in the case proceedings.
That, my lord, is not known to me why he did not come. But in my respectful submission, the notices, definitely, my lord, in my knowledge, my lord, all the notices of the demarcation notices, in the last, there is a bottom line which says, my lord, generally it is written there that Dokhol samjhai diya nahobo. Possession will not be handed over. They can demarcate only.
That is what they are saying.
That is what I am also saying, my lord.
Demarcation.
If they are not handing over the position, then whether these guruns can be protected by the high hander of the police or the state authority, my lord. Tomorrow, I have lost everything. My bread and butter has been snatched. My right to life, my livelihood, that shops were being closed down. we have not been allowed to go inside and open our shops.
Dispute
There is a
question
broad,
of facts.
well, my friend was not there. And this is not in his instruction by the government authorities to say.
Whether my friend was there, Lordship.
This is my
If
instruction.
that is the thing, Lordship.
This is my
our-
instruction. I am saying in broad
it is the
daylight,
high
my lord,
time to leave our
my
profession,
lord,
Lordship.
my lord,
The high time.
my lord will appreciate. It has been telecast everywhere. All news channels were telecasting this. I can show the video. Still, it is in my mobile phone. Kindly appreciate.
Mr. Somoa, so far this telecast business is concerned, will not say more.
But
Will not say more.
I understand.
Because when I was on the other side, I experienced one. How these are telecast.
No,
I'll not
not
say
my respect.
I'll not say
Lots of
much.
people appreciate on that. The fact remains that the shops were covered by tin barricade, my lord. We have attached photographs. Nobody has denied that.
Yes, that is why appreciating that we took it as an urgent case.
My lord will appreciate, at
I
least
appreciate.
kindly make some arrangement so that we can go inside and open the shop. We may be evicted following due process of law. That is the only prayer. And in the meantime, my lord, we issue notices. They will come up with affidavit.
Well, issue notice, but as on that it is difficult to come to a conclusion.
No, I'm not asking for any conclusion. my lord.
Served a notice also to respond number 5 by Dusty also. It will be convenient for you to, because he is
Because
your
he's my
owner.
landlord. I'll do it.
And since 6 is represented already by Mr. Dubey, there is no difficulty
We'll serve him a
to
copy.
consider the case for interim relief on the returnable date, which
My
will
lord.
be very soon,
My lord.
very soon,
My lord.
say for 22nd January.
My lord.
22nd.
My
January. In the meantime, you place all the records.
But one protection, well, if the person inside damages all the shops and remove our properties, there will be nothing left for us. It's the only protection that we.
So far, materials inside the shop or closed shops are concerned, the respond numbers 4 shall ensure. Yes.
It is difficult, Lordship, because Lordship, this is his submission. That the police authorities as well as the circle officers were there. They are denying. Now that disputed question of facts come, it is maybe the private respondent number 5 or private respondent number 6 who have put that tin barricade. So regarding that protection of that, Lordship, the state authority, whether that is why I'm placing, Lordship, it is purely a disputed question of facts. He will not be able to prove without there being any evidence.
There is no dispute that the barricades were done, installed
Let him
there.
keep a vigil. Let him keep him vigil.
And Lordship, if his man goes there and takes away something, Lordship, again that responsibility.
Nobody will be allowed to go inside, my lord, then.
This is not the procedure, Lordship. When I am submitting, why he is disturbing, Lordship? We have never seen such kind of procedure.
On the disputed property.
That is also, Lordship.
Have a look out.
But that point may be kept open, Lordship, the disputed question of facts. As because these things are to be proved by way of evidence, Lordship.
Heard Mr. A. Somoa, Learned Counsel for the petition. G. Hazarika, Planet Standing Council, Revenue and Disaster Management Department for the respondent number 1. H. Sharma, Learned Additional Advocate General, Additional Senior Government Advocate.
2, 3, and 4.
For the respondent number 2, 3, 4,
And
and
7.
7. Also heard. Your file gave it.
Okay. Can I make one submission? My instruction is only to your lordship record. My instruction is that they have taken away all their belongings from there.
No.
There is every possibility, Lordship. There every possibility, Lordship.
Also heard Mr. R. Dubey, Planning Council, appearing for the respondent number 6. The petition is 4 in number. comma, have stated that they are tenants under the respond number 5. So they came in occupation of the shop premises in a building named Kothari Supermarket located at Village Moidam, Moza Beltala. After execution of tenancy agreements with the predecessors of the respondent number 5, and they are in occupation after such tenancy agreements come out the swap premises since a long period of time running into decades. So the petitioners have alleged that the respondent number 3 and the respondent number 4, in concert with the respondent number 6, had acted high-handedly on 22 December 2023. As they had on the said date, barricaded the premises of Kothari Supermarket by erecting tin sets, and as a result, the petitioners are prevented from running their business from the said shop premises, as the petitioners are not in a position to enter into the shop premises since such barricading on and from 22/12/2023. In support of their contentions that they are bona fide tenants, the petitioners have annexed the tenancy agreements executed by them with the respondent number predecessors of the respondent number 5. By instituting the present writ petition, the petitioners have inter alia sought relief in the form of a direction to the respondent authorities to remove the barricades and are erected by them in and around the premises of Kothari Supermarket so as to restore the petitioners in the position as on prior to such barricading. When the writ petition was moved on 4/1/2024, the learned State Council was directed to obtain instruction as to what prompted the action of barricading. Full stop. The premises of Kothari Supermarket on 22/12/2023. Full stop.
That may be kept as a part of the record, or should be inserted.
Mr. Sharma, Learned Additional Senior Government Advocate, Assam, has placed copies of instruction he has received from the respondent number 3 and the respondent number 4 in the form of communication bearing number so and so dated 6/1/2024. And a report of the respondent number 4 dated 7/1/2024. From the documents annexed to the said communication and the report, it transpires that the dispute is with regard to a plot of land measuring 1 bigha, 2 kathas and 17.77 lessers covered by DAG number 90 and KP Patta number 397 at village 2 number Moidam Gaon, Mauja Voltela. Full stop. As per the communication stroke report, the respondent number 6 was the single recorded patadar in respect of DAG number state plot covered by DAG number 90 and seeking demarcation of the said plot, the respondent number 6 had submitted an application on 29/11/2023, which resulted into registration of a demarcation case, demarcation case number 75/2023. Full stop. As the respondent number 5 was found to be connected with the matter of demarcation, notice was also issued to him apart from other stakeholders, other owners. As the respondent number 5 was found to be the patadar of the adjoining plot, DAG number 91, notice was issued to him along with the patadars of other adjoining lands like DAG number 88 and DAG number 92. Full stop. As per the reports, demarcation of the area of land covered by DAG number 90 was done in presence of the stakeholders, but in the said demarcation process, the respondent number 5 was found to be absent despite receipt of notice. The version advanced by the respondent number 3 and the respondent number 4 in their communication stroke report is to the effect that after demarcation, demarcation was done without any disturbance. And as such, the allegation about high-handed action on their part was denied. Full stop. The respondent number 4 has however reported that on receipt of the first information report from Kishan San Gupta and others on 26/12 2023. The same was initially registered as Bokisto Police Station Z General Diary entry number 31, and thereafter, and after conducting an inquiry and receipt of a report, inquiry report, comma, the FIR has been registered as Bokisto Police Station case number 5/2024 on 4/1/2024 for the offences under sections 143, 341, 447, 448, 461, 420, 436, 506 Indian Penal Code, and the investigation has been initiated. Para.
It is 427, Lord.
Ah.
Under section 461, 427.
Hmm?
Last page, Lordship, of my.
Okay. Okay, last page पर लिखी बटन हाँ right. The version projected by the respondent number 3 and the respondent number 5 have been vehemently objected by Mr. Somal when it comes to appearing for the petitioners, and has rated it. He has rated the submission that the on 22/11/2023 a group of about 20,200 stroke 2050 persons had forcefully barricaded the premises of Kothari supermarket, and the petitioners have been asked to move out from the shop premises. Of such an forceful act could not have been committed by a group of 200 stroke 250 persons without the knowledge of the respondent number 4 and the respondent number 5. Most of it is submitted by him, but the deprivation of the petitioners from the preventing the petitioners from running their businesses from the shop, their respective shop premises, which have been under their occupation since a long period of time by virtue of tenancy agreements, would amount to deprivation of their livelihood. So stop. The respondent authorities are could not. The respondent authorities are duty bound not only to cause investigation in respect of the offense registered White Bookstore Police Station case number so and so, but are also duty bound to restore the sub premises to the petitioners as the entire actions of preventing the petitioners from running their businesses from the sub premises are illegal. Full stop. Illegal, full stop. That too, comma, instance at the instance of a private individual like the respondent number 6. The facts presented in the petition and projected in the communication stroke report of the respondent number 3 and the respondent number 4 would require further consideration. Also, issue notice return on 22/1/2024 as so and so appeared accepted notice, no formal notice. The petitioner shall take steps for service of notice for service upon the respondent number 5 by registered post with AD within 2 working days. In addition, the state compliance affidavit on or before 22/1/2023, the matter of
24
matter of restoration of the sub premises in the possession of the petitioner is kept open for consideration on the returnable date.
Lordship may keep the instructions as part of the record.
Communication bearing number so and so and report dated 7/1/2024 of the respondent number 4 placed by Mr. Sharma so and so are kept part of the as part of the record.
There are 2 records, Lordship, one from the
Communication of circle officer
Lordship as well as
6/1 and report of the respondent number 4 dated 7/1 are kept part of the record.
My lord may express the view that I prayed for some amount of protection, the properties that are still inside.
Regarding that, Lordship, I have objections, Lordship, because
My lord,
if
I
it
don't
was taken away,
understand. My lord, I don't understand that
his
my landed
understanding
friend.
will not do, Lordship, as because his private
No, no.
property, Lordship,
No,
whether
how
he has
can
taken
he-
away.
How can he stand for a private goons, my lord?
No,
He's standing for
Private
government.
goons?
He's a.
Lordship,
He
this
is
is too much, Lordship, at least
No,
that
no.
much of, that
No,
much
no, my
for no,
lord.
Lordship.
No, my lord. I am praying for the protection of life and liberty. This is this duty of the government, and my landed friend standing in favor of the government, on behalf of the government, opposing this prayer.
It is a livelihood.
No, Lordship, it's a livelihood. He's not running his shop. No, it's
How
very
can he?
careful.
How can he oppose this
Then your
prayer?
Lordship direct us to
How
remove
can
the
he
barricade.
oppose this prayer, my lord? Kindly appreciate.
Shall I consider this your prayer?
No, my lord.
Interim prayer. Let us consider it.
My lord, my respectful submission. We have lost our livelihoods. Some amount of protection that.
Lordship, let him submit, Lordship, thereafter.
Aspect, I have
When I am submitting, Lordship, let.
I'm just praying for an innocuous thing. Very innocuous. Lordship will pass an order that their properties shall not be disturbed. This would be that the.
Okay. The respondent number 4 shall considering the above sequence of events, it is observed that the respondent number 4 shall keep a vigil.
Yes.
Keep a vigil in respect of the area of land covered by DAG number so and so and demarcated on 22/12/2023.
Lordship, at least, Lordship.
Vigil means watch.
No, Lordship, at least some, to that extent, he should have that much of. Lordship,
I'm not
they are saying, Lordship, I am protecting the goons in the open
This is
court,
not,
Lordship.
not appreciated.
I also know, my lord. I apologize for this, but the thing is that
But it's too much, Lordship.
my
This
learned
type-
friend
this
is
type of
standing
case
for
should
the
be stopped,
government.
Lordship.
My lord, my learned friend is standing for the
If he
government.
has taken away all the goods, Lordship,
My
what
lord,
will happen? Tomorrow, all the burdens will come upon
No,
us.
how can it be? That is why.
When my learned friend is saying that,
That
are
is why-
whether
that is
I
why
was
there
present
should
at
be a
that time,
vigilance.
most probably
Yes.
my learned was present at that time.
Item number 13.
It has gone to our profession to that extent, Lordship. I'm sorry, Lordship.
Yes, what is your
Wait.
case?
My lord, I have paid for furnishing certified copy of my order, my lord. That is not furnished to me, my lord.
Huh?
I have made an application before the authorities to furnish the certified copy in order in original, my lord. That is passed against me, my lord. It was never served on me. In a departmental appeal, I came to know that order has been passed. Therefore, I approached the authorities for furnishing this copy, my lord.
No, what is the case? So-cause notice was served or not served?
Focus was served. I
Where is the so-cause notice?
My lord, it is
Okay, this is 12,
12, my lord.
30/12/2020.
20.
Then what happened?
I have submitted my reply.
Reply, which one?
So I have not annexed, my lord. Reply was submitted. I have made a statement, my lord. Reply was submitted. Thereafter, matter estate does.
Huh?
My lord, reply was submitted, my lord.
Huh.
After submission of reply, my lord, no communication received from the authorities. Thereafter, my lord, on 27/23, a notice was received from the appellate authority from Guwahati, my lord. That is so-called, that a hearing has been fixed, my lord.
This one, page 29.
My lord.
Huh?
My lord.
Okay.
This notice was
This
served.
you have received.
Yes, but this notice was served on the petitioner, my lord.
Hmm.
Apart from this notice, nothing was served on the petitioner. The petitioner appeared before the authority. On appearing before the authority, my lord, petitioner came to know, my lord, the so-called notice has already been adjudicated, my lord. A part of the demand has been dropped, a part of demand has been confirmed, my lord. The part which has been dropped against that department has preferred an appeal, my lord. Then on attending the hearing, my lord, they not only came to know, my lord, the order has been passed, my lord. Thereafter, I make some application before respondent number 3, my lord. That is at page 46, my lord. Requesting them to furnish me a copy, my lord, so that I can take steps in the matter, my lord. It was submitted on 20 of October, my lord. But they have not considered till date, my lord.
Your page 46 is half or what?
No, the page 47 is there, my lord.
Yes.
See, I think there is no difficulty in supplying copy, but before that, Lordship may come to page 43, paragraph 11.
43. Yes, 43.
Personal hearing of the case was fixed on 22/8/2023.
Which 43, which paragraph?
Paragraph 11, Lords, last paragraph. They appeared on 22nd August 2023 before the appellate authority. Nothing was stated whether copy was served on that day. They said that the order in original was wrong. Can be inferred that they were order was with them on that day.
Otherwise, page 47, certified copy of the order.
Yes, sir.
If he is reiterating the state submission, then what is the certified
No,
copy?
no, there is no difficulty. I'll direct my authorities to
So when he can appear to receive the certified copy?
next Monday.
My lord.
That's all?
Yes, sir.
You heard Mr. R.S. Mishra, Learned Counsel for the petition. And Mr. S.C. Kyle.
For 2 and 3 lots.
Okay. MS,
P. Tamuli on behalf of Ms. K.
Miss
K.
K. Fukwa. CGC for 1. And Mr. S.C. Kyle, Standing Counsel GST for the number 2 and 3. The petitioner has submitted that he carries on his business as Messrs. Deposit Bora, paragraph 2, and the seed form, property form, has been registered with the respondent GST authorities. Post of the petitioner has service tax registration number para 3. The petition was served with a show cause notice bearing number H 12 dated 30/12/2020. Demand comes show cause notice. Asking him to show cause. As to why. So called within 30 days from the date of receipt of the notice as to why service tax of rupees 1,27,17,421 and interest, penalty, etc. Should not be recovered from him under section 73(1) of the Finance Act, RW section 142 within bracket 8 within bracket small a, CGST Act 2017, along with penalties, interest, penalties, etc. So the petitioner has submitted that he submitted a reply in response to the said demand come show cause notice on, submitted reply on
Date not there.
on
But date is not there.
on
12/1/21 lots. 12/1/21.
12/1/2021. Full stop. The adjudicating authority, it appears the petitioner has averred that the petitioner was not aware about the passing of the order in original by the respondent number 3 on 3/6/2022. So the petitioner was made aware of passing of the order in original on 3/6/2022 when he received a notice to appear for personal hearing notice dated 27/2022 23 to appear for a personal hearing in connection with an appeal which has been presented by the department against the order in original dated 3/6/2022, right?
My lord.
Full stop. The the respondent authorities, sorry, the respondent number 2 or what?
Three.
See, my lord.
No, this order has been passed. This page 31.
They have not made the appellate authority the response.
It's not made him party.
The respondent number,
He's not a party, man. He's the appellate authority, man. Commissioner appeals.
he passed the order or what?
No, he passed
This is an order or what?
order in
It's the
appeal, my lord.
order, the appeal of the department was dismissed.
By an order in appeal dated 6/9/2023. The commissioner within bracket appeals dismissed the appeal prepared by the department against the order in original dated 3/6/2022 passed by the respondent number 3. Full stop. It is in the above sequence of events, the petitioner stated to have submitted an application before the respondent number
3, my lord.
3 on 17/10/2023, requesting him to furnish a certified copy of the order in original dated 3/6/2022, so as to enable the petitioner to take appropriate steps in the matter. So, as the certified copy of the order in original dated 3/6/2022 has not been furnished to the petitioner till date, and the petitioner has prepared the instant petition. Para Mr. Cal and standing also GST has submitted that in view of the limited prayer made by the petitioner as regards supply of a certified copy of the order in original dated 3/6/2022, the petition can be disposed of at the motion stage itself, as the departmental authorities is agreeable to furnish a certified copy of the order in original dated 3/6/2022 on an whenever the petitioner appears before at the office of the respondent number 3. Full stop. He has submitted that if the petitioner appears before the respondent number 3 on
15 office is open, lords. On 15,
15.
the office is open, but
Can it be on 18 because the
But
Bihu,
Bihu holidays
on
18, my lord.
18.
Lords.
On 18/1/2023 4, a certified copy of the order in original dated 3/6/2022 will be supplied to him.
Lords.
Full stop. Mr. Mishra and counsel for the petitioner has submitted that the petitioner would accordingly appear before the office and before the respondent number 3 on 18/1/2024 to receive a copy of the certified copy of the order in original dated 3/6/2022. In view of the above submissions made by the land council for the parties, the writ petition, it is not necessary to continue to proceed with the writ petition, save and accept directing the petitioner to appear before the respondent number 3 on 18/1/2024 and save and accept directing and directing the respondent number 3 to supply a certified copy of the order in original dated 3/6/2022 to the petitioner when he appears before him on 18/1/2024. This disposal of the writ petition.
Order stay vacating item number 21.
Lordship, I humbly pray for adjournment today because I checked the records. I found that some of the petitions are not with me.
Okay.
I want it.
After Bihu then,
My lord will extend the intent.
Date may be,
maybe in February.
no, Lordship.
Very few working days are here. Maybe on 2nd of February.
All right, Lordship.
Okay. B.K. Bhagavati, Land Council for the applicant, has submitted that due to inadvertence,
Can
he
it be
could not bring the entire brief today, and has thus sought for an adjournment. So Mr. B.D. Deka, Land Council for the opposite party petitioner, is present and has no objection to a said fair. Has agreed to by the Land Council for the parties, leaves the case on 2.
Can it be
Two.
5th, my lord?
5th, 5/2/2024. The interim order passed earlier shall continue till the next bit of listening.
Item number 57.
Tinta was available? Oh, Tinta. Oh. Yes, Mr. Roy, anything urgent?
One matter. My lord, item number 24, my lord. Lordship may.
You can take a chance after this matter if this matter does not prolong.
Or
Yes.
Oh, here it is.
Lordship, Mr. Kane Chaudhary is on legs actually.
We can start or
Yes, Lordship.
on the other day also, it was because of his.
Okay. After 30 minutes then. After 30 minutes. Yes.
Item number 22. Infliction of parties.
Yes, what is the application?
application was for impleting of the.
Why connected petition? You are a petitioner there.
Yes, Lordship. The main case relates to the.
As the Sharma, the allegation is lack of action to remove a shop which according to has been illegally constructed. So in expect copy of the notice to the entity. Made a party respondent. You want removal of a shop or
Yes,
what?
Lord- Yes, Lordship.
Why?
Because that is on the ingress and outgress
Remove
of the
the illegal
petitioner.
shop established by encroaching the road at the corner of so and so. Open Hazarika Pot Kharguli, Assam. Okay. Yes. State Council,
Instruction.
any objection?
Agreement, no objection.
Heard Mr. S.J. Sharma. Land Council for the applicant. Their state petitioner. MSS Shutia Land Council representing Mr. P. Nair. Land Standing Council, GDD and GMC for the opposite party number 1 and 2, MS and MS. M. Bormon, Junior Government Advocate Assam for the opposite party number 3. The instant interlocutory application has been preferred by the applicant. Thus, petitioner seeking implement of for the following person, that is for as a party respondent in the connected petition. The applicant as the petitioner, has preferred the connected petition alleging inter alia that the proposed party an illegal shop has been constructed by encroaching the road at the corner of first left by lane of Dr. Bhupen Hazarika Pot at Karguli, Guwahati. Full stop. The petitioner, the applicant petitioner has preferred the writ petition seeking entirely a direction to the respondent authorities to remove the said shop. Full stop. The applicant in the instant interlocutory application has averred that the proposed party respondent has been running the said allegedly illegally constructed shop, and as such, the presence of the proposed party respondent in a connected writ petition is necessary. Full stop. The learned counsel appearing for the opposite parties have submitted that they have no objection if the instant interlocutory application is allowed. Full stop. In view of the statements and averments made in the apostate manner that it is the proposed party respondent who has constructed the shop illegally and has been running the same. Thereafter, the instant interlocutory application is allowed. See, to stop, the office shall make necessary correction in the cost title of the connected writ petition on submission of an amended cost title by the petitioner, by the learned counsel for the applicant petitioner, writ petitioner, within 2 days from today, and thereafter, list the connected writ petition in the connected writ petition the next week. Highly amended cost title. And again, he took a repetition, had Mr. Swenso can separate video. The office to release the case immediately after submission of the amended cost title by the learned counsel for the petitioner in terms of the order passed today in I Civil 3887/2023.
May I please, Your Lordship? Your Lordship, Mr. R. Pujari appears for this matter, Your Lordship. Your Lordship is under bereavement to pray for adjournment of the matter for the day, Your Lordship.
Better to have a case on a date, hearing date.
Hearing
2018.
2008.
8-2.
Right.
Okay. Mr. S. Nath, learned counsel for the petitioner, and Mr. H.K. Das, learned standing counsel, GH petitioners, 1, 4, 5 are present. MS R.M. Borwa, learned counsel appearing for Mr. R. Borpujai.
Yes, Your Lordship.
Learned, he appears for finance.
Finance Department.
The standing counsel finance department has submitted that Mr. Borpujai has some personal difficulty today, and the matter be listed after 2 weeks. As agreed to by the learned counsel, as sought to by the learned counsel for the parties, sought for by the learned counsel for the parties, list the case on 8-2.
Bless you, Lord.
Item number 24.
Matter, this matter pertains to demarcation matter.
Perhaps you are not in possession of the land.
No, I'm not in position.
Then how can you ask for demarcation?
My lord,
Demarcation can be done which is of a area of land which is in your possession.
No,
If your lordship will see the chapter 3 of that particular regulation, it says if there is a dispute on the exact position, on the aspect of position, that demarcation survey can be dealt. Now, he was never in possession of that particular proprietor of the land. So he was never in possession. It has been always a case that I was in possession, pursuant to the land being settled by the government.
But
And
lordship may
his sale
see,
deed is after my possession or that settlement.
If I remember that these three petitioners, right?
yes, 3 petitions.
They purchased land by registered sale deed.
Registered sale deed.
But as on date, their lands are inside the
Yes,
boundaries of Oil India.
Oil
Exactly.
That
That
is
is their
their
claim.
Yes. Now
So demarcation, if you have asked for demarcation of an area of land which is not in your possession, it will be difficult to pass such an order.
Even the circle officer has come to a conclusion that Oil India is in excess of their allotted land.
Maybe, but we are also to think about a direction which is not conceived of under the law. They may do so anything, but I have to, whatever order
Look
is
at the
to be
merits of the
passed,
matter of the
is to be
claims.
passed as per the provisions of law.
Yes.
The land, because this court has already held that the demarcation, in another case, the demarcation of the area of land in particular specific position of the petitioner can be made. If I can direct that is, but things will come into zero, is it not? Admittedly, you are not in possession of the land.
That is admittedly I'm not in position.
And from
But-
92, there has been no institution of any civil suit or anything
No,
claiming their right at
no,
or even for our
I
ejectment.
am
If they are saying
claiming
that I am in
throughout,
possession
I'm-
of their land,
Throughout,
nothing.
I'm claiming the land, my lord, which is within the boundaries of and even the circle officer wants to do the demarcation, but All India has not cooperated, my lord. That is the position. And because of that, I'm before this honorable court, my lord.
Claims have to
Right.
be looked into on
Lordship,
their
yes.
merits.
Circle officer can demarcate the land.
Yes, I want that circle officer should demarcate the land matter to the extent. I'm not asking that the land should be handed over to me.
Then you better prefer an appeal before the deputy commissioner.
No, that I have.
Because admittedly you are not in possession of the land.
Lordship may just peruse some of the documents, my lord. The lordship.
No,
may-
the sum and substance of the case is that you are not in possession.
I'm not in position. But my lord, the circle officer, even the I will report to the DC also.
I cannot be party to a circle officer.
Yeah,
I will not sail with circle officer.
definitely, my lord.
He may do so. Am I clear? He may do so. He may proceed with the demarcation. But I will not party to a process where admittedly you are not in possession of the land. Now your land is somewhat lost.
Somewhat within, if the lordship sees the All India, my lord, that was the finding, my lord, that 7 bighas an odd land has been.
It is not that forceful. Encroachment or hostile encroachment. Somewhat or other, they came into
But
position
if
of.
it is held that, my lord, that excess land is held by the All India, at best I will get the compensation, my lord. The land has to be acquired by them because as an authority, they can't have an excess land.
How to find out this?
It's a bounded campus, and in 92 only settlement has been made. And the
But
sale deed is
I
after
purchased 92, their acquisition is 95, my lord.
that. Notice is prior to that. Section 4 notice is prior to that. Section 6 notice is prior to that.
If they show that the land has been, compensation has been given to me from the record, I have placed the record
Suppose
also.
even if your neighbor,
Mine.
let us take oil as your neighbor. If they have come into occupation of your plot of land without any kind of hostile takeover, forceful occupation,
Yes.
right? In that case, even if it is government also, then also the recourse for you is not a writ proceeding. Had it been, yes, circle officer, deputy commissioner, along with oil authorities have gone to your place and get hold of your land. Find out the observation in one particular case. I think Syed Maqbul Ali. Even if it is government who without any hostile situation came in encroachment of a private individual's land, then also
And hostility is not there.
Hostility is not there.
Because when we took possession, there was no objection from his side in 1992. So therefore, now in 2023, how can he say that we are in possession of his land?
Then that would be a cause of action for a civil remedy.
At best, a suit of ejectment.
Or otherwise, maybe a case of maybe a survey to locate your land. That is a different thing.
That's a different thing.
Only a survey. Do you know demarcation? I'll not sail with circle officer.
I understand, my lord.
Lordship is going to go on the merits of the case or of their claims, not by the circle officers.
I'll not go into circle officers demarcation process.
Lordship knows how these things happen nowadays.
I'll check it. My lord.
Check up.
Please.
Recourse may be
Civil remedy, my lord.
Lordship was referring to one judgment of your lordships regarding that demarcation thing.
somewhere reported.
I'll find out. I'll find out.
Okay, Mr. J. Roy. Heard Mr. J. Roy. Counsel for the petitioners. Why you are sitting for so many years?
My lord, I'm trying to making representation after representation, my lord.
That will not extend the period of limitation.
But
Mr. Vijay Talukdar, he appeared. Senior counsel. This is said by Mr. P. Methi. For? Okay. And Modular, standing counsel revenue 1, Vijay Talukdar, and senior counsel is by Mr. P. Methi for the respond number 2 and 3, and Mr. H. Ramal, and counsel for the respond number 4 and 5. Full stop. When?
My lord,
As sought for by Mr. Royal and counsel for the petition, and raise the case on
29. 29, my lord.
29.
20. So can it be on 31 Lordship?
31.
31. 29.
Holiday.
31 is holiday.
Holiday.
Then February,
February.
any date.
Two.
Yes,
Second.
Lordship.
Second
Yes.
February.
Obliged also.
Thirty minutes বুলি কলো না আকৌ এইকেইটা কিবা আছে নেকি মাটি মঞ্জুৰ দেৱীটো মাটি
Map please, your lordship. Item number 58, lordship. Can be taken up some other day, lordship. I'm not feeling well, lordship.
Mr.
58.
A. Sharma,
Yes, sir.
Learned counsel for the petition has paid for listing of the case on another date. Post of list the phrase is the
Date
case
may fix, lordship, after vacation.
after vacation. The other day.
Any date, lordship.
We'll find out a date.
Item number 25.
Obliged.
Yes, affidavit is filed.
Government has filed affidavit, my lord, but without giving any reason, only opinion has been given. Kindly see their affidavit, my lord. One paragraph, page number, running page, my lord, 60. Running page 60. Therefore, from below, second paragraph. Therefore, if government feels that it is a fit case to order for withholding of pension under Rule 20 of pension rules, as mentioned above, it can proceed accordingly. Government himself filed affidavit that government.
Next paragraph is crucial, my lord.
Why you are shy of taking a firm opinion, firm view in a matter? Why you feel like this and that? It is you who has to take the view.
Yes, my lord.
You cannot feel like this today, feel like that tomorrow. There are repeated orders.
Yes, one side it is stated
No.
conviction.
Yes, Mr. Das, we cannot go on like this. We'll take a final call.
My lord, it appears from their affidavit, I have seen decision is already there that my lord, if you last paragraph, your lordship kindly see. In view of the conviction of legal position pointed out above, the petitioner is not entitled. But they have to pass an order. They have to pass an order. It cannot go on like this, my lord. They have to pass an order
My lord,
that under so and so provision, you are
We'll
not
take a
entitled.
call in name in name.
Yes.
We'll fix the date.
my lord, one thing may I point out, my lord. Disciplinary authority, my lord, came to an opinion at page 38 that regarding page 38. An opinion has been given in page 39. From the above, it is found that Government of Assam reserved himself the right of withholding or withdrawing the pension or any part of it permanently or for a specific period, and right ordering and recovery in pecuniary loss cost to the government if any departmental or judicial proceeding is found guilty and grave misconduct and negligence during the period of his service. It may be noted that as per inquiry report, if interest imposed on the above recovery, the recovery will be double amount. The delinquent has already retired during the period of proceeding, and he was also convicted in a criminal proceeding. His service is wholly dissatisfactory. Only
Suppose the delinquent had suffered conviction in
Yes.
2 cases.
Yes,
Criminal cases involving 409.
yes,
Is it not? That position has not been
not been changed.
changed.
But regarding my lord,
That is,
pension,
I think that should have been the end of all.
end of all, but
I
they have not.
to benevolence of the judicial department, you have continued to receive benefits.
Till today, the government has not taken any decision. my
Today will not be able to. We'll do it on 6th of February.
Lordship.
Tuesday, we'll close it. In the meantime,
I will.
may take for the final
Yes.
view in view of the paragraph. Heard Mr. S.K. Ghosh, Learned Counsel Board of Petitioner. Mr. M.S. J. S. Sharma, Learned Senior Government Advocate Assam for the response number 1, 2 also?
Yes.
And 3, 1, 2, 1 and 2.
Yes.
And Mr.
3 and 4, man. 3, 4, 6.
H.K. Ras, Learned Standing Counsel, CHC for the response number 3, 4 and 6, and Mr. D. Rabha, Learned Counsel for the response number 5. Full stop. The response number 1 and 2 has filed its counter affidavit on 3/1/2024, observing inter alia that it may proceed as per the provisions of Rule 20.
My lord, 20 is not applicable here in this case. This is also a 21 is applicable.
It may proceed in accordance with the
With law.
provisions of
Yes.
Assam
Services and pension.
Pension Rules 1969 as amended. List the case on 6/2/2024. The respondent authorities, respondent number 1 and 2 may in the meantime proceed to take a final view in the matter as per the provisions of the Assam Services Pension Rules 1969 as amended.
Much.
Next.
Deeply obliged.
For the timing, lordship.
Not for a timing, some other day. On the prayer of Mr.
J.I. Mundal.
A.I.
J.I. Mundal.
J. Mundal Learned Counsel for the petition, the case is adjourned for the day. Ms. S. Sharma, Learned Junior Government Reporter Assam for the state respondent is in attendance. particular.
Yes. Lordship, this is regarding this Guwahati Kabristan Committee, Lordship. On the expiry of we are the earlier office bearers of the committee, and on the expiry of our term, which is for 3 years, an election meeting was held. But due to some unruly situation, the election became failed election. Therefore, thereafter, some few participants who participated in the election, in the failed election, they declared themselves as a members, office bearers, and they were running the committee. Now, presently, some few members of the Muslim community has approached the learned civil judge, and the learned civil judge, white order dated 4/12, has stated restrain the new members, new office bearers to take the affairs of the Kabristan committee. And presently, there is no one to run the affairs of the committee. Therefore, we have approached the deputy commissioner who has the power to interfere into the.
But the deputy commissioner has any power?
Yes, Lordship.
Under what provision?
Under the provisions of.
Let us see.
The Assam, page number 25, Lordship. The
Page?
Assam State Acquisitions of Land.
Page 25.
Yes, Lordship.
Let us see.
The Assam State Acquisition of Land belonging to religious or charitable institutions of public nature, Act 1959, Lordship.
This is acquisition of land.
Is under this section 25 is there, Lordship.
Huh?
Section 25, page number 38.
25.
Page number 38, Lordship. Section 25.
Page number?
38, Lordship. Section 25A. Mayor, Lordship. For each of the religious or charitable institutions of public nature, a managing committee shall be constituted with the following members to have a control over the matters of utilizations of the annuity and verification of the proper maintenance of the institution. Under bracket A, the deputy commissioner of the divisional officer or his nominee president. So the deputy commissioner has absolutely have the power to interfere into the affairs, Lord. And on the earlier occasion also, the deputy commissioner has intervened into the affairs, Lordship, which is in page number 44, Lordship, Annex 4, into the similar given circumstances. Page number 44, Annex 4, Lordship. The deputy commissioner has passed a similar order, Lordship, on the earlier occasion.
How whether this Kabristan is a religious institution?
Yes, Lordship.
Huh? How can you say? Yes, MS Sharma. You were asked to obtain instructions.
Yes, my lord, we've written to them on more occasions than one in the
Right,
past.
Mr.
L. Sanktam, Lordship.
S.
L. Sanktam, Lordship.
Sanktam, Learned Counsel for the petitioners and Ms. S. Sharma, Learned Junior Women Advocate Assam, for as per number 1 and 2.
1 and 2.
So, Sir MS Sharma has submitted that no instruction has yet been received. As regards the prayer of the petitioner, so she has sought for further time to obtain instructions as regards formation of a managing committee for Guwahati Kabristan. The prayer is allowed, is the case after 3 years. Without. Yes, material. Yes.
Hello, 57.
I will just call my senior.
Okay, make matter. Next matter 29.
Item 29.
May I please, your lordship. My lord, this case relates to the, my lord, the custom authority has detained my vehicle, my lord. During the pendency of the case, my lord, they made an inquiry, my lord, which they have been done by the DTO Silchar. And DTO Silchar has clarified, my lord, if your lordship permit me, I'll submit the copy. And it said, my lord, there is no such box as alleged by them, my lord.
I got this.
So in view of that, in view of that, my lord, my vehicle, they have detained illegally, my lord, right from August, 8 August, my lord. They ought to have released the vehicle. Time and again, I have approached to the custom authority, Shillong also.
Mr. Borgin cannot hand over a document.
No, my lord,
like
just
this
for showing,
in
my lord,
respect of a custom case concerning how much rupees of imported item?
Important item, my lord, around 34
What?
lakhs. 34 lakhs.
34.
The case of that, my lord, I have given my vehicle to my driver under agreement, my lord. He ran the vehicle, my lord, with the fixed.
That is the normal story always.
My lord, I have annexed the document, my
We'll
lord. I have
see,
given
we'll
a
examine
statement
that.
also.
Want to bring it on record so that he can afford some.
Lordship, on 5th of January, the petitioner wrote a letter to the authority to reduce the value of the vehicle. That is under consideration probably by within a day or two, final order will be passed.
Okay.
My lord, that is altogether different, my lord. Now, my lord, my vehicle, if it is, my lord, detained illegally, then they are answerable for that, my lord.
Not illegally, Lordship, while
I cannot take
No, my
cognizance
lord,
of that
lordship,
letter,
lordship,
Mr. Bormiya.
lordship.
Otherwise, records suggest that there is a chamber secret cavity in your vehicle.
They said, my lord, on the last occasion, your lordship was pleased to ask for the record, my lord.
And
Record
I have
will
asked
reveal
Mr. Kyle, and whether there is a possibility of releasing that vehicle on bond.
yes, Lordship, that
Provisional release, you are seeking provisional release, right?
The judgment also I have annexed, my lord.
earlier it was rejected after intervention of the Honorable Court. Lordship authority has completed the entire proceeding. Within a week, Lordship order will be passed.
If you can, if you have estimated the value of the vehicle, definitely they are looking into
Release of the vehicle.
release of the vehicle.
My
When
lord,
can be
so-
expected?
Within a week, Lord.
Within a week.
Lordship, can it be fixed, my lord, on Thursday or Friday, my lord? My
Within a
vehicle
week,
is-
he is saying within a week.
My lord, on the last occasion also same story was repeated.
Okay.
Lordship fixed the date, my lord.
1919. Mr.
On-
Bormiya,
My lord.
learned, heard Mr. Bormiya, learned counsel for the petitioner, G.I. Bormiya. And Mr. Any Union of India, anybody?
My lord, custom will do, my lord.
Mr. S.C. Katz, learned standing counsel, customs.
Lords.
For the number 2, 3, and 4 of Mr. The subject matter of the petition is provisional release of a vehicle.
Release of the vehicle, my lord.
Provisional release of a vehicle. Where in respect of which the petitioner is the registered owner. Full stop. The vehicle was seized in connection with
DRI case.
offenses or
My
offense
lord,
registered or not registered?
Registered.
Register, my lord. DRI case number 2.
DRI case number 2 of
21-22.
under the provisions of the Customs Act.
Dated, my lord, 17/8/21.
The matter of sorry, full stop. Mr. Cal, Land Council, Standing Council Customs, has submitted that the respondent authorities are estimating the value or what? Are
Value of
making
the
valuation.
value of the truck is 20 lakhs.
Are making valuation of the seized vehicle. And the said process will be completed within a week's time. Within a week's time. Full stop. List the case on 19-1.
And
My lord,
petitioner also filed an application for reducing the value. Lord. That is for.
That is not, my lord. I'm not concerned with that, my lord. It is the matter between the petitioner and them, my lord.
You are the petitioner.
But I have come, my lord, only for the release of the vehicle. Why it is released?
You are the petitioner, Mr.
So far, my lord, he is saying, my lord, throwing ball
You are
on
making-
my court, my lord. That is not that, my lord.
he is saying.
He let him say, my lord, whatsoever.
By
And,
submission may be recorded, we have received the letter.
my lord,
Okay.
as per my lord,
Mr. Kayal has further submitted that an application to that effect was received. An application for valuation of the vehicle was received from the end of the petitioner.
in respect to particular vehicle, my lord.
One vehicle only, how many?
My lord, they may say other thing also. That's why I mentioned.
This is too much. Next.
My lord, only one thing, my lord, lordship, as per 19/9/23 lordship's order, my lord, to produce the record, my lord. That may be retreated.
Everything is with me, Lord.
That may
Record
be
is there.
retreated.
I can produce.
Record is there.
My lord, that may be there.
Oh, you.
Order stay vacating item number 57. My lord, before my learned friend starts, can I
Yeah.
just point out one thing, my lord? Against the order of the learned single judge, they went in appeal.
Hmm.
And in the IA, my lord, they have annexed the order. Now, whether your lordships would like to deal with the IA or petition as a whole.
We don't know. We don't know because
the issue is-
yesterday express urgency we fixed at
Yes.
3 p.m.
No,
I am not
no,
aware
my lord,
that
if a lordship would kindly come to page 143 of the IA, 143. That's the order of the
this appeal was preferred for what? Against interim order.
against interim order and it appeal was preferred. Instead, the division benches, my lord, said that the learned single judge may be requested for taking up the whole matter in substance. Please come to 146, my lord.
146.
There are 6, 7, and 8. We have considered the submission advanced by the parties to the proceeding and also perused the materials on record. And we are of the view that in the fact situation involved, the legal issue which have been formulated by the learned single judge has not been considered finally. The issue so formulated is to be first adjudicated in the writ proceeding and not in the present proceeding. Now, my lord, the issue formulated by the learned single judge is, once, my lord, the term of the bank guarantee expires, whether by an ex parte agreement, which is done behind my back between APTCL and the bank, my lord, it can be enforced against the petitioner. That is the issue which the learned single judge formulated. So in that view of
Let
the
us
matter,
have a cursory look at the issue.
at the order of the learned single judge, my lord, that will give a clear picture.
Okay.
Yeah, that order is at page number 140, it starts, my lord. If your lordship would kindly come to 141.
In the IA.
No, yes, in the IA. Law is firmly settled that invocation of irrevocable bank guarantee cannot be injuncted by the court, save and except upon fulfillment of at least one of the two grounds, that is practicing fraud and irretrievable damage to the parties. After going through the materials on record, this court is of the prima facie opinion that none of the above conditions are fulfilled in this case. However, the larger question that confronts the court in this case is as to whether bank guarantee which has already expired can still be encased at this point of time without extending the validity period of the same, merely on the basis of an agreement entered into by and between the bank and the employer, wherein writ petitioner is not even a party. This is more so since particular clause in the bank guarantee relied upon by APDCL apparently runs counter to the terms and conditions reflected in communication dated 4/1/21, which makes bank guarantee valid only for a period of 22 months from the date of signing of the purchase agreement. This court is therefore of the prima facie opinion that there is a genuine controversy involved in this case, which should require further consideration by the court.
Where is that bank guarantee?
Yes.
Page 121. Starts at 118.
The relevant clause is at page 120.
118.
18.
My lord will kindly come to page number 123. Last sentence towards the bottom. These bank guarantees shall be valid up to 21/4/23. Similarly, at page number 127, this bank guarantee shall be valid up to 26/1/23. Similarly, my lord, there's one more at page, I think, 119.
119.
Yes. There are
Similarly worded.
similar. Only date is in two cases it is 24/1/23 and in one case it is 26/1/23.
Now, what is the offending clause?
Oh, yes, offending clause is at page 120, my lord. We are liable on top. We are liable to pay the bank guarantee amount only and only if we receive from you at our address stated below a written claim or demand not later than 1 year from the said expiry date, failing which all your rights under this guarantee shall extinguish and we shall stand completely discharged. So this is an agreement between APDCL and the my lord.
Where is that?
Sorry, bank.
PPA.
PPA is my lord 15/2/21. There is no dispute on that.
Let us see the PPA.
PPA to quote আছে বাৰু?
Page 57.
Draft PPA. Pro forma.
Yes.
This is pro forma.
It is pro forma, yes.
Okay.
Actually, the date is, my lord, PPA date is 15/2/21. There's no dispute on that. So therefore, I feel, my lord, lordship may take the matter for final disposal. Any date convenient to lordship.
The final PPA panel as
Okay,
executed is at
this
page
clause-
76.
this is- Which clause governs?
My lord.
Which clause governs this, the bank guarantee? Which clause in the PPA governs the bank guarantee?
Okay. No, my lord, there is a letter. If a lordship would kindly,
For purchase.
yes, no, a lordship will kindly come to the letter of award, my lord. Page 76 of the writ petition.
Letter of or repetition.
Yes. Page 76.
In terms of.
Yes, in terms of RFS, power purchase agreement is to be signed within 30 days from the date of issuance of this LOA. Copy of the PPA is enclosed. Here it is annexure 1. Please come to the, my lord, Roman 1, 2, and 3. Performance bank guarantee for an amount of rupees 84 lakhs.
No, before that.
In terms of.
Clause B, fifth line. As per the format provided in Schedule 3
Yes.
of PPA. Where is the Schedule 3?
Yes. Page 57 আছে না?
Schedule 3.
One second, my lord. It starts at page 56 of the IA. Schedule দুটো দেখা নাই নাকি?
Page 118 also says Schedule 3.
Yes.
Schedule 3.
Yes.
Schedule 3 is not annexed.
As per the format.
As per the format.
That format.
As per the format that is indicated in letter of award. Anybody available?
Not
readily. It doesn't form part of the PPA. It does, unfortunately, that Schedule 3 does not form part of the PPA.
Then how can the petitioner has been able to
It is.
submit
May I
the
point
bank
out?
guarantee in form of Schedule 3?
My lord will kindly come to, but if your lordship will kindly take up the IA for a moment.
Page 18, I am saying.
Your Lord-
118, 118.
Before that, my lord, I'd like to point out one thing.
No, no, before that, I want to indicate 118.
My lord,
Schedule 3.
that is mentioned there, but
Bank will not get Schedule 3.
no.
Petitioner on his own will not get Schedule 3. It is the FPDCL who can give the prescribed format in Schedule 3.
We can check up, otherwise, my lord, it does not form part of neither the tender. The only thing I wanted to point out to your lordship is, if your lordship will kindly come to the NIT at page 19.
NIT.
Because all these things that are done pursuant to the letter of award are in terms of the NIT itself. Now, if your lordship kindly, page 19 it starts. If your lordship will kindly come to page 55, it is a continuation of the NIT. Clause 21 of the, after the letter of award, how the agreement will be executed is here, my lord. Clause 20 speaks about the letter of award at the very top, page 55. And immediately after that, your lordship will kindly see signing of project agreements and financial closure. The successful bidder or the SPV formed by the successful bidder, as the case may be, will execute the project agreements upon satisfying the following conditions within 30 days from the date of issue of the LOA. 1.1.1 is signing of the project agreement. Next, 1.1.2, submit the performance security or performance bank guarantee or equivalent in the form of bank guarantee in accordance with the provisions of the RFS. So this was submitted. It was not that it was a agreement merely made between the bank and us. It was he who submitted this. And he was all along aware of this particular clause at page 120.
Right. Because this Schedule 3, that is as per prescribed format. Right. So this prescribed format is part of the draft PPA or draft bid document.
It ought to have been.
Might be.
It ought to have been, but it is not.
How can
So now
this court would like to examine whether that offending clause is part of the Schedule 3 or not.
will have to file an affidavit.
If that is part of the Schedule 3, that might close the door or window for the petitioner.
That is true.
Is it not? Because whether is it a law that the bank guarantee, there should be the validity period of the bank guarantee and the claim period should be one and the same. Is it a law?
No, that is what is our case.
Right, that is why I want to know.
No, my lord. Well, I'll have to lay my hand to get the case law on the point. But prima facie, my lord, LOA says I need to furnish a bank guarantee with a validity period of 22 months. So beyond that, can you enforce? No, I have noted what has fallen from your lordships. I'll apply my mind to that. Now, my lord, they are trying to enforce a
Where is the
clause.
clause regarding performance? This is performance.
This
I have placed that, my lord, writ petition, page 76. That's the LOA.
That day, that's true.
Kindly see, my lord.
Somewhere it is there.
PGB for an amount of rupees so and so having validity up to 22 months from the date of signing of the PPA. And PPA is 15 to 21. Page 76. In fact, I have submitted, my lord, bank guarantee of 4.2 crores. We have submitted. And in terms of this LOA. That's why the learned single judge, my lord, on an earlier occasion has formulated the point whether a bank guarantee which stands expired that can be invoked.
Come to page 60.
Of the writ petition, my lord.
IA.
Yes, my lord.
4.4.
Yes, performance guarantee.
I think that is the bank guarantees.
Yes.
There also format provided in Schedule 3. Schedule 3. So this is draft.
So my lord will kindly appreciate when this agreement was executed between the bank and the employer, we are not privy to that, my lord.
That is why.
Therefore, they will have to
But
go
it
by
was
the
he who
form.
submitted. It was he who submitted it.
No, I submitted the bank guarantee. I never submitted this agreement. But how can the, my lord, I'll give only their instrument, legal instrument.
Legal instrument is a bank guarantee.
Yes, that we submitted.
No, whether
But
how.
regarding this, terms and conditions of this agreement, that I'm not privy to it, my lord.
How this offending clause has surfaced in the bank. That is the issue.
That they will have to explain. We are not party to
if
that.
if it is as per Schedule 3,
Then it's okay.
then it's okay.
Yes.
Because here the draft also, let us see your power purchase agreement executed 4.4 in the agreement.
Agreement is at, my lord, first agreement is at page number of the. If you lord-
Executed agreement, I think that is here.
Yes, yes.
Page
Please come.
76,
Page 76.
4.4.
Yes.
It is there. Same, 81.
Well,
As per format provided in Schedule 3 and having validity up to 22 months from the date of signing
Of the PPA.
PPA.
Yes.
Only thing is Schedule 3.
my lord will kindly come to page 110. This will make the position, I think, slightly clearer.
Why don't you give the Schedule 3?
Schedule 3 is not there, my lord. That is what I was pointing out. Page 110, immediately after Schedule 2, page 110 is Schedule 2. If your lordship kindly turns the page, your lordship will find it straight away comes to
That
attach.
presumption will go against you. Presumption might go against you. You are repeating in the draft
Yes.
PPA, in the executed PPA,
Absolutely.
that this is in form of Schedule 3. Please furnish bank guarantee in form of Schedule prescribed Schedule 3. Right. So court wants to know what is Schedule 3.
It is unfortunately, my lord, due to perhaps some inadvertence, that was not.
Otherwise, he cannot draft the bank guarantee
Yes.
on his own.
No, he cannot. But your lordship will kindly come back to this page, my lord, page 55, and simultaneously have page 118, my lord. What is he required? Page 100, page 55, 21 point, thereafter on the subclause 1.1.2. He has to, it is he who submitted. Submit the performance security, and your lordship will kindly turn to page 118. Your lordship will find that this is the performance security.
No,
118.
format is prescribed by you.
That is the difficulty in this case.
How can I-
It does not form part of the
My
enactment.
lord,
you have the prescribed
my
format.
learned friend is harping on this 1.1.2. Who is disputing? I have not given the performance guarantee.
Performance
Performance
security
guarantee
is
is not an issue. Issue is that particular clause at page 81.
performance security is submitted. This is the performance security as page
The point
180.
is one, whether the
Is as per
bank
Schedule
guarantee
3.
can have two periods, that one validity period and another claim period. That may be one of the issue. But if that is yes, can have two, then if claim period for another 1 year from the expiry of the validity period is inscribed or prescribed in the performer, then definitely.
Even otherwise, my lord, rightly or wrongly, there is an agreement.
No, because I am
Security.
asking, because nobody has addressed on a particular issue. That is why I am asking.
But this is, my lord, we can even put it on affidavit.
No, otherwise, this 1 year has been interpreted in a different manner altogether. That is why I am asking.
We can put it on
There
affidavit.
are
also.
lots of legislative history. That is why I am asking.
But in that case, my lord, let us put it on affidavit. That
You get the performer tomorrow. Otherwise, this incorporation of offending clause may not be activated against the petitioner.
I mean, affidavit we are going to open.
In other
Your
words,
lordship will fix it on Thursday. In the meantime, my lord, by tomorrow, if it
I
is
can
there,
fix it, but I will not be there. I can fix it, no issue.
no, lordship can
because
fix it
our
on
urgency,
Monday.
our urgency is
Monday is, that Monday will come after Bihu.
after Bihu, and by then it will be 23rd. It will
18th, my lord.
By then, my lord, it will be too close to the 23rd of January, my lord, is the last
Fix
day.
it on Thursday or
Let it be on Thursday. my lord.
Friday.
Our urgency is, my lord, otherwise, if that date also goes by, then we'll be in very, very serious difficulty. Let it be on Thursday, we'll file, if necessary, we'll file.
That is why I am asking you.
My lord, if necessary, we'll
There is
file.
a reason behind it.
I get the point. We'll, if necessary, we'll file
This
an appeal.
1 year period has a relevance. Whether it is claim period or something else, it is for you to find out. Okay. I, Chaudhary, Senior Counsel, assisted by KP Pathak, applicant APDCL, and Mr. Ken Chaudhary, Senior Counsel, assisted by MS
R. Kakot.
R. Kakoti, Learned Counsel for the opposite party, that's litigation. Full stop. As sought for by the Learned Counsel for the party, release the case on Thursday. Full stop. The parties may make endeavor to provide a copy of the prescribed format in Schedule 3. Prescribed format of the bank guarantee in Schedule 3 as indicated in clause 4.4 of the draft power purchase agreement.
No, the final is also the part of the record.
Same.
Final is also the same.
Power purchase agreement.
PP.
Your name, okay. Okay, you can address on this point, please come. Just have an idea from Mr. Sharma. Just two Chaudhurys, just. What is this according to you? 1 year.
Yesterday I got the brief from the.
Oh, that's Mr. M. Sharma, Learned Counsel for the respondent bank, is also present. Your name is reflected or not?
Yes, yes. Please.
Okay.
Item number 30.
Please, madam.
What is this case about?
Okay, this is with regard to.
Such bulky
This is with regard to reimbursement of.
affidavit in opposition? What is this bulky affidavit in opposition?
Lots
What is the subject matter?
Lots of the petitioner is praying for reimbursement of his training costs under the, he has executed some training.
Reimbursement of your
under the
contractual dues.
Yes,
No, lots of, the amount, I had earlier approached the honorable court, the amount is very small, 5,96,000. After coming into court, then there is a court order, lots of, they have paid an amount of 387,579. Now they have withheld an amount of 2,09,206. The earliest time was that lots of, there is a cutoff date that we should submit the bills within a cutoff date of 2/6/2011. There is a notification. Now, in this affidavit, they have taken a stand that we have not submitted the engagement certificate of the passed out candidates. Now, in our affidavit in reply, also I have brought on record, also the engagement certificates of the passed out candidates, which says that also that we have already submitted, and they have also make a statement that they have called the passed out candidates in their telephone numbers, but they were not responding to their calls. So it proves that they had also the phone numbers of the passed out candidates. And also even my bank guarantee of 50,000.
What do you say about the affidavit in reply?
My lords, this is a summary suit in disguise of a writ petition. They're completely in breach of their contractual obligations. There is an arbitration clause as well, my lords. They have completely ignored that.
Only thing is that when courts finds that there are disputed questions of facts involved, which require factual determination on the basis of evidence, yes. But sometimes it is not that the money claim cannot be a part of a writ proceeding.
Please.
But question is that whether you have raised the issue that you have disbursed a part of the amount and withhold a part of the amount. Now they are saying that they have submitted the necessary documents to you.
Yes.
Or whatever as part of the affidavit in reply.
Yes.
Now, have you gone through these documents?
Yes.
Then you
have page number 162, man.
Of
running page number 162. Man. I'm on a very short point.
My lords, this was the condition of contract which they were supposed to fulfill under the contract. The outstanding payment that my learned friend is contesting on is a contract condition which they were supposed to fulfill as per this condition. Now, what happens is, my lords, this is the third installment which was supposed, according to him, is due and payable. According to me, I'm disputing the entire facts altogether. The actual facts of the matter is that within 3 months of conducting the final assessment, they were supposed to place the candidates, my lords. Now, if my lords have serial number 15, condition number 5, the TP, which is my learned friend, he needs to produce a joining letter and 3 months of salary slip and 3 months of bank statement, my lords. Now, we conducted, as per the cost and process norms, my lords, we conducted an independent investigation into the documents which he has placed on record. I'm not disputing that he has not filed the records in the department. He has. On the basis of what he has filed, I have conducted an independent investigation and found certain things to be fraudulent and therefore denied his claim. This is a serious fact that I'm raising, my lords.
Again, Mr. Das.
Lordship, that inquiry is conducted in 2022, whereas Lordship, we have passed out in 2018. They may not be engaged in that same organization, Lordship. They may have.
Jurisdiction as regards money claim is very limited.
Lordship.
Unless the rights of the petitioner is crystallized and without any dispute, then only the decision can be passed. If they are disputing, then we cannot enter unless genuineness of the claim is disputed, then how can we enter into that? That is a difficulty.
Yes. But this inquiry is in
If you go by, say,
2023.
right from Tamser Ali,
Tamser Ali, yes.
right from Tamser Ali, or there are many other, unless it is not admitted by the respondent, a money claim in a writ petition is not to be entered in. That is the difficulty.
Then also we will go to the arbitrator, but in the meanwhile.
No, arbitration is that
arbitration clause is there.
contractual. There are two things. You are exercising a right under a contract that does not give right to violation of fundamental right. That gives right to violation of contractual right, for which you have to go to the other forum. This will not give rise to violation of fundamental right or infringement. You have entered into a contractual relationship. Unless they are admitting it is difficult.
Lordship, the earlier petition was disposed of by this honorable court, Lordship. May I kindly see that order?
Yes, we disposed maybe.
And that was
representation. What?
It was on a limited point for me to consider.
Representation.
In the earlier petition also, they have filed the affidavit. I have broken record the earlier affidavit filed in my affidavit reply. That was a part of the affidavit reply.
Page 72.
The running page.
No, this page 71 of the repetition. Municipal 33.
No,
same 33.
Yeah.
Page 70.
In the earlier petition, they have.
What was the amount? 5,96,785.
Yes, sir.
Then come to page 70.
Page 70, yes.
Then come to the prayer. After hearing the learned counsel for the parties.
Yes.
To file a representation.
Yes, my lord.
Along with the stating its grievances pertaining to non-payment of rupees 5,96,000 so and so. Right?
Lordship.
So they considered, examined, then allowed the prayer to an extent.
But in their affidavit, they have admitted.
What there? Where?
Lordship, at page, running page is Lordship 546.
546.
Is the affidavit filed?
548.
5?
548 he is referring to, my lord. Running page number 548.
No, it starts
No,
with
what is this
500.
bulky one?
The bulky one is the counter affidavit.
Counter affidavit filed by ASDM.
Response number 2. Then again this, you have filed 2 counter.
No, my lord. He's
I have filed
filed an affidavit in opposition to my counter.
I have filed my affidavit in reply to his counter.
And this 548 is what? Affidavit in reply.
546 is the affidavit in opposition filed by the respondent number 2 in the earlier round of litigation also.
Huh?
In the earlier round of litigation also, they have filed an affidavit. I have brought on record.
1 minute, 1 minute. There is one affidavit by respondent number 1.
Yes, my lord.
Yes.
Okay. Then what you are referring to? Your affidavit in reply.
Yes.
Okay.
In my affidavit in reply, Lordship, I have brought on record, Lordship, the affidavit in opposition filed by the respondent number 2 in the earlier writ petition, that is writ petition number 730.
Okay.
And Lordship, in that case, Lordship, their main stand was that, Lordship, there is a notification at page 554. 554. Their objection was that all the training, Lordship, has found 554.
554.
54. Yes. It is hereby informed to all the TPs, TCs who have been allocated targets in financial year 2017-18, and that notification dated 2/6/2021, Lordship. That the third installment payments are cancelled effective 2/6/2021 for those TPs who have not claimed payments within 3 months of date of assessment and placing the certified candidates. Further, for targets allocated to training in financial year 1920, he is hereby issued to claim the third installment within 3 months of placing the certified candidates as per norms, or else the same will be cancelled. So their main objection was with regard to that we have not submitted.
My lord, this point has already been disposed of.
On 2/6/2021.
He's talking about the earlier rate. This point has already been considered. It has been disposed of after the directions of this honorable court have considered this
Now, in
document.
this affidavit in opposition, they have filed this bulky affidavit. Their stand is that we have not submitted our certificate.
No, I'm not saying that, my lords. I'm saying they failed verification.
No.
Are categorically.
Where is your verification and result?
Yes, my lords.
At page 87, running page.
My lords may have annexure 4, running page number 220, my lords. The bulky affidavit. Out of all the candidates that have verified, my lords, only one verification came.
Where is the statement? I'll not go into
Page-
this part one by one.
Page 86, Lordship, paragraph 5, F.
Where is just I'm asking him.
Yes, my lords. Page number 86, my lords. Running page number 86, para F. My lords have it? My lords may have page number 83, my lords, where that's where it starts, para D.
Specific statement.
Yes, specific statement, my lord.
Will not go into those.
Yes, my lords. It starts at para D, my lords. I'll take you through the entire pleadings as it stands. my
Not,
lords.
no such pleading is required.
No.
For an amount of rupees, disputed amount of 2 lakh. Court is
My lords.
this bulky affidavit is not worthy of
My lords.
going through.
My lords, I
Tell me the statement.
Yes, my lords.
Specific statement. That's all.
My lords, para D, it's that the petitioner is not entitled to nor eligible for any amounts claimed under under the instant petition towards a third installment for batch ID so and so and batch ID so and so. There are two batches, my lords. One is for training of for tailors, and one was for both are tailors, my lords. For the reason that in order to be eligible for the payment of any amount towards a third installment for a particular batch, the petitioner was required to complete placement of at least 50% of the candidates in the batch within 3 months of the candidate passing the assessment. It is further submitted that the petitioner did not submit the complete and proper documents within the stipulated time. However, that is moot now, my
How
lords.
much amount out of this 3,87,579
Lordship.
paid?
Yes.
Paid. How much out of 5 lakh?
Lordship, they have paid 387,579. On
If they are not admitting that the remaining amount,
remaining amount is only 2,09,206, Lordship.
we are
My
not.
Lordship, I am a poor entrepreneur, Lordship. For them, Lordship, this amount may be small. But I have taken loan.
So how
and
can we decide?
Lordship.
How can we decide if they are disputing it? Tell me any law that even if dispute is raised, court can pass an order for payment, taking support from Tamsir Ali.
Lordship.
Take the support of Tamsir Ali and submit, if it is possible.
Lordship may kindly come to their affidavit in page 86, there stand F, paragraph F. They have said petitioner's claim conducted by respondent by following up with the candidates tell themselves by telephone. Only 2 out of the 30 candidates in the category of self-employed tailors in batch number so and so received calls.
My lord, all that he is raising are tribal facts.
Heard
F.
Mr. S.K. Das, Learned Counsel for the petition. And Mr.
K. Khanna with M. Das, my lord.
For both.
For respondent number 2, my lord.
Who is for one? Mr. S. Sharma, MS.S. Sharma, Junior Government Advocate Assam for the respondent number 1, and Mr. K. Khanna, Learned Counsel for the respondent number 2. The petition. You are what? A registered body or what?
Yes, Lord. I'm a training partner.
Huh?
Training partner under the mission director, Assam Skill Development Mission.
Has preferred the instant petition. Under Article 226 of the Constitution of India, seeking interior directions to the respondent authorities to disburse an amount of rupees 2,09,206 with the allegation that the said amount has been illegally, arbitrarily and illegally withheld by the respondent authorities. The petitioner has claimed that petitioner has claimed that it is a registered organization and it is a training partner, TP, empaneled for imparting training and providing placements as per the policy of the Assam Skill Development Mission, ASDM, subject to fulfillment of the terms and conditions laid down. It is a case of the petitioner that as training partner, TP, comma, it entered into, yeah, what are the standard? It entered into an agreement dated 19/3/2018 with the response number 2 for implementing the Assam Skill Development Program with a target of training the youth of Assam and imparting short-term modular skill development training so that the candidates can have gainful employment thereafter. Full stop. In course of time, after the execution of the agreement, the petitioner submitted a proposal under the Assam Skill Development Mission, and the response number 2 had issued a sanction order stroke allocation advice on 23/20/2018. Thereby granting approval for a job self-employed tailoring under placement linked state funded scheme provide ID number of batch ASDM so and so for 380 hours for the period with effect from 3/5/2018 to 3/9/2018. It is a further case of the petitioner that after successful execution of the job, what is the total bill?
Total bill was 5,86,000 something.
During the execution of the job, the petitioner used to raise bills and the respondent number 2 after received the bills, is to sanction the bills, full stop. It is the further case of the petitioner that when an amount of rupees 5,96,785 was not disbursed by the petitioner had approached this court earlier by way of a repetition. WBC number 732/2022 seeking inter alia direction to the respondent authorities, more particularly the respondent number 2, directing to reimburse the training cost for the courses under the ASDM amounting to rupees 5,96,785. After hearing the parties Hearing the land counsel for the parties, the writ petition. WBC number 732/2022. Huh? Okay. Was disposed of, by an order dated 1/4/2022, with a direction. Reserving the liberty to the petitioner to approach the respondent number 2 by way of a fresh representation as regards his grievances pertaining to non-release, non-disbursement of the amount of rupees 5,96,785. Full stop. It was further observed that in the event of submission of such a representation, the respondent number 2 shall consider the same as per the entitlement of the petitioner and in accordance with law by taking into account the services rendered by the petitioner. And if no impediment is found as regards the release of the said amount, the same can be released within a period of 60 days from the date of receipt of a copy of the order dated 1/4/2022. Full stop. Where it is pursuant to release of an amount of rupees 3,87,579 pursuant to submission of a representation and consideration of the said representation in deference to the order dated 1/4/2022 Sutta. The petitioner has preferred the instant writ petition seeking inter-alia direction to the respondent authorities on the ground that an amount of rupees 2,09,206 out of the total amount of rupees 5,96,785 has been withheld by the respondent number 2 till date arbitrarily and illegally, and as such a direction for release to the respondent number 2 for sanctioning and disbursing the said amount of rupees 2,09,206 is called for. Full stop. The learned counsel appearing for respondent number 2 has referred to the statements and averments made in the counter affidavit filed on behalf of the respondent number 2 to contend that the bills are required to be submitted in terms of which one? That clause 5? 15?
15, my lords.
Where is it?
My lords, it's running page number 162.
As per the mandate.
As per the cost and process norms, my lords.
Huh?
As per the cost and process norms, my lords.
As per the mandate.
As per the mandate.
Mandate. Contained in clause 15 of the proposed process norms. Full stop. He has further submitted that after receipt of the representation pursuant to the order dated so and so, the claim of the petitioner for the entire amount of rupees 5,96,785 was examined and verified with the records available at the end of the respondent number 2. And after finding the entitlement of the petitioner to the extent of rupees 3,87,579, the said amount was released. Full stop. It has been contended in the said affidavit in opposition that the claim as regards the remaining amount of rupees 2,07,000 thousand. 9,206 cannot be considered for release as there are many disputed questions involved. He has further contended that the sale amount of rupees so and so, remaining amount of so and so, cannot be since so and so is disputed, comma, the instant repetition does not, sorry, a direction to release the said amount of rupees 2 lakh so and so cannot be made in the present date petition. Full stop. Para. I have considered the submissions of the council for the parties and have also gone through the materials brought on record by the parties through their pleadings. A fulfillment of this code in read appeal number 484 2005, Tamsir Ali and others versus State of Assam and others, and similar other 194 petitions reported in 2008 4 GLP 1 FB has observed that a writ petition involving contractual liability can be considered only in the event there is admission of liability certified by the respective there is an admission of liability. Full stop. Para. A writ petition is ordinarily decided on the basis of affidavits. Full stop. In the course of the writ proceeding, comma, the court has to consider as to what facts are in dispute and what facts are not in dispute, and such a stage comes only after the exchange of pleading in the form of affidavit among the parties is complete. Full stop. From the discussion above, it is clear, in the absence of any admission of liability by the respondent, concerned respondent, that the claim, respondent number 2, that the claim of the petitioner as regards the remaining amount of rupees 2,09,000 so and so or any other amount has not been crystallized with any admission of liability. Full stop. The said claim has been refuted by the respondent number 2 on the ground that the petitioner has failed to submit the required documents in terms of the mandate number 15 contained in process norms. Full stop. Thus, it is for the petitioner to establish that he is entitled to the remaining amount of rupees so and so, and to establish but in the obtaining fact situation obtaining the case, comma, this court is of the considered view that a number of disputed questions of fact are involved in the process of adjudication of the writ petition. Post of this court does not generally embark upon determination of questions of fact which demand elaborate examination of evidence to establish the rights to enforce which the writ is claimed. Post of. As these factual disputes have fallen for determination, the same would require appreciation of evidence, both oral and documentary, in a full-fledged trial proceedings. Such disputed questions of rival claims of the parties with regard to disbursement or non-disbursement of the amount of rupees so and so are to be investigated and determined on the basis of evidence which may be led by the parties in a properly instituted civil suit or in arbitration, comma, if provided for in the contract. rather than by this court in its jurisdiction. For the said reasons, the writ petition is found to be not entertainable, and it is accordingly not entertained. It is however made clear that non-entertainment by writ petition shall not preclude the writ petitioner in initiating appropriate proceedings before the civil court or by way of arbitration, if provided for by the contract, for the amount claimed and stroke or damages, losses, and interest, if any, suffered by him in the event any such proceeding is initiated by the petitioner. The same is to be considered in accordance with law and on its own merit and on the basis of the evidence to be laid.
Lordship, one thing is admitted by them. My lordship, performance guarantee of rupees 50,000 deposited by demand draft number. So that is admitted at page 591. That may be written.
I'm holding it, my lords. I have to now initiate case.
Performance guarantee.
Performance guarantee, that may be released.
We
Lordship.
don't know whether fulfillment or not, that is a different.
Exactly, my.
Fulfillment of all the conditions. We'll not go into that, we'll not read the terms and conditions.
But my amount has been deposited.
As a question of release of a performance guarantee is also involved, the petitioner may approach the respondent number 2 by way of a representation seeking release of the said performance guarantee. And if such a representation is filed, the respondent number 2 shall examine and consider as to whether the petitioner number 2, the said performance guarantee is entitled to be released as per the terms and conditions entered into terms and conditions of the agreement entered into by the parties.
Obliged.
Any interim order, continue. I have a meeting.